Yes.
May please. My lord, for motion, my lord, on Monday, my lord. My lord, my AGM of the Cooperative Society of the Prisoner, my lord, has been refused to approve, my lord, by the
Cooperative Society.
my lord.
Cooperative Society is, I think, bench 3. है ना?
Bench 4. No, 4.
Bench 5. It is not bench 4. It is not bench 4. Cooperative Society is not bench 4. It is not Cooperative Society. We're not dealing. You're the first. You're the first case that has come. Bench 5 or bench 4? You do.
I'll check.
May I please the lordship? Lordship, item number 31.
31. Yes.
Taken up next week, lordship. I need some instruction, lordship. Therefore, I have taken consent of the other sector.
Okay, right. Ms. R. Devi, learned CGC, says that the matter may be listed after a week. She submits that she has taken the consent of the petitioner.
Yes, sir.
Huh?
Petitioner's consent has been taken.
Petitioner. Accordingly, release this matter after the week.
There is also lordship 2014 matter, lordship for dismissal from service. It may be taken up for
Dismissal from service.
yes, lordship.
From the labor court.
No, yes, lordship.
I do not know. I mean, let it come in its own turn.
Yeah, please, your lordship. Lordship, I beg to mention item number 30, your lordship.
30.
Yes, your lordship. I have the consent of the other side as well. They have filed your objection yesterday, your lordship. We want to file our reply.
Madam, what is the term of the Mandir committee? What is the term? What is the term? You find out and then you tell me. Yes, next.
May it please your lordship, my lord, with the consent of the other side, I beg to mention item number 35, my lord. Here I am appearing for the petitioner, my lord. My landlord senior is appearing for the ONGC, my lord. Here, lordship, I could not contact the petitioner, lordship, for so long. Lordship may grant me some time so that I could contact him, and if he's willing, then I will continue, otherwise I will withdraw the matter.
Miss,
MD Bora for the petition.
you want to withdraw what?
Lordship, I will get instruction from my client, my lord.
With regard to, actually, your client is ONGC.
My,
He has no contract with that client, my lord.
I am for
Oh.
the petitioner, is a depository Bora, lordship, regarding blacklisting of some vehicle. ONGC.
You want some modification of some order also. So what to, so we wait. Miss MD Bora, learned counsel for the writ petitioner, submits that she has not been able to communicate with her client and accordingly seeks some time to communicate with it. Accordingly, leave this matter after
After 3 weeks, my lord.
after 3 weeks. Mr. Jain Sahawala appears for the ONGC.
I'm deeply obliged. Deeply obliged.
May it please, your lordship. Lordship, I beg to mention item number.
Anyway, I was thinking at least the IA we could dispose of or not. No.
What happened, my lord? This brief is also not with me because I was engaged the present justice. You can
Anyway, okay. Right. Okay. Yes.
May it please, your lordship.
Obliged.
I beg to mention item number 19, lordship. It is in the motion follows. Lordship, we want to withdraw this petition. Actually, lordship, there is some mistake in annexing the
Okay. Okay. Right. So, Miss, what is your name?
lordship and Dekaraja.
Miss,
And Dekaraja, lordship.
appearing on behalf of
Vice Mandan, lordship. Lordship, kindly allow us to.
item 19. Okay. Okay. Miss N. Dekarajia
Lordship, kindly.
says that she may be allowed to withdraw the writ petition
Lordship, with
with liberty to file a file.
yes, lordship.
Who is appearing for that side?
Yes, yes.
All right. Prayer of the petition's counsel is allowed. Writ petition dismissed as withdrawn. Come on, with liberty as paid for.
Much obliged, lordship. May I please, your lordship? I beg to mention item number 27 and 28. That for adjournment, kindly fix the matter after 1 week.
Why do you want to adjourn?
My senior is having some personal difficulties.
I am for the petition, I have no objection.
Okay.
A specific date may be fixed so that it can be.
There's no stay order. There's no stay order.
No, I understand.
Then what is the urgency?
the market which was allotted to me has been given to someone else. In spite of there is a stay order, state of order. So, you know,
You're for the writ petitioner?
My-
Oh. Okay. Uh. You're for the
Respondent number two,
Four.
one and two,
five,
1 and 2.
1 and 2, okay. Right, on the prayer for adjournment made by Miss
A Parasar,
A.
Parasar,
Parasar on behalf of,
P.S. Bhattacharya.
he is not here, his name is not here. Acha, P.S. Bhattacharya, yes. Learned counsel for the respondent number 1 and 2. Which is not objected to by Mr. U.K. Goswami. List the matter after, list the matter on, you did. After 3 weeks.
Especially dates for the. I know.
May it please issue Lordship, I beg to mention, I beg to pray for listing of a writ petition. My lord, notice was already issued last year in the month of July. Lordship, the account of the petitioner in the State Bank of India has been closed in my
Give a date.
13 months. Apply.
May it please the court, my lord. I crave leave to move a mention memo for an unlisted motion today, my lords.
Why?
The urgency in this case is that the subject matter pertains to the rectification of electoral roll. And as the lordship is very well aware that the elections are knocking at the door and it will become a logistical impossibility if the election code of conduct is enforced, my lords. Therefore, it has already been filed, my lords. Copies have
D-voter,
already-
you're a D-voter or what? No.
my lords.
Are you a D-voter? D. No. Delhi, D for Delhi.
No, my lords. It has already been filed and
What is the matter about?
Well, so the petitioner has been, is in fact a resident of the Karimganj district of this state and also possesses an EPIC, a voter card, valid voter card issued by the Election Commission of India, and his name found mentioned in the draft roll. However, his name has been removed from the final voter list without any notice, without anything, and he happens to be an intending candidate also, Mullahs. Now,
Intending candidate.
also, and his name itself has been removed. Now, the urgency in this matter is that once the code of conduct is announced, which is going to happen in the coming few days, then it will become a logistical impossibility. Therefore, we have already duly filed it, and copies have also been served. We have received a number. If it may kindly be taken up today, as an unlisted motion, I'd be highly grateful.
We'll see if time permits.
Yes,
Yes,
Oblige.
last
Please,
item.
Lordship.
Okay.
Please, Lordship. Lordship, I beg to mention for listing of two writ petitions, Lordship. One is related to settlement of market, Lordship, and another is
Pending matter,
Lordship,
pending matter.
pending matter, Lordship.
You have a date.
Obliged.
May please the lordship, that's my recommendation for listing of an IA for correction of order on Thursday.
Okay.
Much obliged.
Please, your lordship, I beg to mention for a listing of withdrawal for tomorrow.
Okay.
Obliged, lordship.
One is a contempt matter. And two is the writ petition.
So we go to the writ.
Better. My lord, the contempt, I think my lord, lordship will not take it very lightly, my lord. There is a clear cut order, despite that they should work on it. It's a very serious matter. Otherwise, my lord, when the very purpose of passing a stay order stands frustrated. Not a very matter which will be taken so lightly, my lord, as the other side is thinking, my lord. It's a blatant contempt of this honorable court. Anyway, my lord, the lordship will kindly have the writ petition. Please come to the tender, my lord. But the matter relates to, my lord, hiring of trucks carrying water, no? Water tankers by ONGC, my lord. And now the matter hinges on a very narrow compass, my lord. Please come to page 177.
Yes,
My lord, the dispute centers around this particular clause. C2, the last one.
yes,
Reader to note that quoted basic running rate per kilometer exclusive of applicable GST should not be less than 0.275 into diesel rate declared by Sibsagar by IOC for Sibsagar as on the TBO to tender technical bid opening date. TBO is technical bid opening date. Now, my lord, what had happened?
but how will they know?
That's the question. That's the issue. Whether this is in public domain. Now kindly see, my lord, if your lordship would kindly come to page 254, what was the earlier practice of ONGC when there was no problem? Kindly come to page 254. This is the tender of 2015. Kindly see, my lord, the third sentence. Reader to note that quoted basic running rate per kilometer exclusive of applicable GST should not be less than 0.25 into diesel rate as on 36/19, that is 65.18%. So there is no issue then.
It is clear.
Clear. Now kindly come to, my lord, page number 262, the other last tender of 2019. Page 262.
Yes,
Bidder to note somewhere in the middle, my lord. Somewhere bidder to note that quoted basic running rate per kilometer exclusive of applicable GST should not be less than 0.25 into diesel rate as on 36 to 2010. That is 0.25 into 79.80. Now, my lord, in this case, what had happened? Please come to page 236.
just a minute.
Yes.
261.
262
No,
and
260.
250, my lord, sorry, 254 and 262
254
is the tender of
Of-
2015.
and 261. No,
262
2019.
is the tender of 2019, where, my lord, the diesel rate was prescribed, was indicated. There is no scope of manipulation. Now, my lord will kindly come to page 236. When I went to Google, my lord, this is what was revealed. Diesel price today in Sibsagar, Assam is 89.49 per liter. No change was recorded in the price in Sibsagar since yesterday, that is March 5th, 2023. Rate has remained unchanged in Sibsagar for the past 2 days in a row, keeping the price steady since 5th of
Okay, let us see what is the NIT dated.
Yes. Well, there is no date, but it was issued in the last year, 23. Date to 9.
2023.
20.
What is the last date of submission of bid?
6th, my lord, page number 29. 6/3. Serial 5, my lord. Date and time of opening of the bid. 6th of March 23.
No, 2 o'clock at 6:03.
Yes, 6th of March.
And this Google that you have got is 6/3/23.
Yes. 89.49.
Okay, on the same date.
Yes, same.
So you have got to submit your bid on the last date.
Yes. So I quoted this. Now I am out because, my lord, why? Now please come to page 237. There is one petrol pump called Damani service station. There the rate was, my lord, 89.49 on 6th.
Yes.
Then please come to my lord, page 238. Sorry, 239. Page 239. This is Lohit Fuel Service. HSD price is 89.16.
On the same day.
Yes, my lord. Please come to page 240. This is another dealer. His Relimex Services. His rate is 89.70. Lordship would recollect, I approached earlier this honorable court. At page 271 is the order, my lord.
Yes.
This was the order, my lord. I'm reading para to page 272.
Yes.
The petitioner's prayer in the writ petition is that respondents number 2 and 3 should take a decision on the petitioner's representation dated 2303 in terms of clause 38.1 of the e-tender. He submits that clause C.2 of the bid evaluation criteria, which is at page 169 of the writ petition, could be subject to different interpretation, and such clarification of the same is required. G.N. Sahala, learned senior counsel appearing for the respondent number 2 and 3 submits that wordings in clause C.2 does not leave any room for other interpretation other than what is clearly reflected therein. Bidder to note that a quoted basic price rate as per kilometer exclusive of applicable GST should not be less than so and so rate declared by the IOC. Hence, we submit that in view of the clarification made by so and so, he would like to withdraw the petition. My lord, the impression which was given to our lordship was there is only one price on a particular day. So we withdraw. But when my financial bid was evaluated, then I found that I have quoted a higher price because I quoted 89.39, which was the price of the my lord IOCL, which I got from Google. Now, I submitted a representation still thereafter, which your lordships will get at 274. Please come to the last sub-parameter at page 274. That, sir, in the tender, being tender number so-and-so is totally silent, in respect of quoting minimum or maximum HSD rate, on the contrary, there is a specific terms and conditions in the price bid. Note in clause number C.2 that if the basic running rate are quoted less than the basic minimum rate per tanker, kilometer per tanker, such bid will be rejected. So I cannot quote less than, my lord, the rate of the IOCL outrightly. That, sir, after submission of the tender paper and opening of the technical bid on 6/3/23, it has come to the knowledge that in different HSD filling station of IOC in Sibsagar district itself, HSD rates are not same. Rather, it varies from HSD filling station to station. In fact, there is no one fixed HSD rate fixed by IOC in Sibsagar district on so-and-so. That is on the technical bid opening date. So I have given the dates. That's the HSD rate of IOC was shown to be 89.49 as per the website of the IOC on TBO, that is 6.3, which is still reflecting in the said website. That's since there is variation in the HSD rate in different IOC filling station in Sibsagar district, as mentioned above. Supposing a bidder submitted his tender quoting the rate of 89.49 per liter in terms of IOC website, which coincidentally corresponds to the rate fixed by Damani service station. In that event, the final price bid of the said tenderer might get rejected if another tenderer mentioned his HSD rate in terms of the rate fixed by one Lohit Fuel Service, which fixed its HSD price at 89.16 per liter, less than the rate quoted by the other bidder, and accordingly, there is every possibility to declare the said tenderer as L1 who quoted the rate of Lohit fuel service. This sort of discrepancy would not have occurred had there been one fixed rate, HSD rate in all HSD filling station in Sibsagar district on tender submission date by the tenderer. That, sir, although there is no mention of minimum or maximum rate in the NIT being so and so, but in the website of the IOC has uploaded a document informing showing 89 as the HSD rate on TBO that is 6023 in Sibsagar district. Since said document is a part of the NIT itself, as such, HSD rate must be considered as fixed minimum rate of the HSD for the purpose of tender process. Therefore, ONGC cannot come and say that there is other HSD rate as on so and so other than the rate shown in the website. Now, my lord, I'll just show the concern of the ONGC. Now, what they did, my lord, if your lordship will kindly take the affidavit filed by them. So my case is very simple, my lord. Since I quoted 89.49, the rate which was, disclosed in the IOCL website, I have been rejected because according to them, the rate is, my lord, 89.16. So I cannot quote less than the IOCL rate. So therefore, my technical bid has been rejected. Now kindly see, my lord, the affidavit filed by them. Please come to page number 322 of the affidavit filed by ONGC. Now kindly look at the midshift, my lord. Please come to page 322. They are referring to some mail between, my lord, ONGC and IOCL. I'll not reading the contents. I'll read it from my affidavit in reply.
This is mail from?
This is from, my lord. This is from Indian Oil. Basically, my lord, Indian Oil to ONGC.
Dated?
This is dated, my lord, September 14, 23.
Yes.
Kindly see, my lord, the contents towards the end. Thank you for your prompt response. In addition to above, please confirm that whether HSD rate for Sibsagar as declared by IOCL on daily basis on your website or any other public platform. This is very significant. Because as a member of public, it must be available.
There has
to
to
me.
be a standard.
Yes. So, my lord, these are the comments.
No. So this is from the IOC to the ONGC. What is the relationship between them?
My lord,
The
IOCL who produces and sells, my lord.
And the ONGC?
And ONGC is the employer, tendering authority. ONGC wants those, my lord, water tankers for supplying water maybe to their factory, residence, etc. Now, my lord, they are withholding one very vital document which we have annexed in our reply. Now, kindly come to our affidavit in reply, page number 375. This is the, my lord, midship. They have not come with clean hands. Please come to page 375. Sir, in the price format of the subject tender, the following note is present. Bidder to note that quoted basic rate per kilometer exclusive of applicable GST should not be less than 0.275 into diesel rate declared by IOC at Sibsagar as on the technical bid opening date. Bidders should quote the running rate per kilometer based on HSD rate declared by IOC for Sibsagar as on technical bid opening date. If basic running rate are quoted less than the minimum basic price, such bids shall be rejected outright. Now, next page is very important one. This is the discussion of the ONGC, my lord, which they are sharing with.
No, one thing, this 375
Yes.
is not there at 322.
Yes, they have not annexed it because it goes against them that we have annexed. In fact, they produced it before this honorable court and the motion stage, my lord. Kindly come to page 376.
Yes.
As per the discussion held in the TC meeting on 11/9/23,
TC
technical technical
committee,
tender committee.
tender committee.
On 11/9, indenter is requested to get the confirmation information from authorized representative of IOCL that whether IOCL declares their HSD rate for Shivsagar in public domain on their official website or internet on daily basis or not. Because they are conscious, ONGC itself was conscious of the fact that since we are imposing a condition which is correlated to daily announcing of the and whether it is available in the public domain. Further, in case they confirm that they update their HSD rate for Shivsagar on daily basis on their official website, kindly obtain the URL of the said ONGC.
URL meaning?
Uniform resource locator. Well, these are the terms nowadays, my lord, has come over. We are, my lord.
You're a dinosaur in this modern day and age.
Yet to cope up with those expressions, to be honest. So, my lord, the ONGC authority was conscious of the fact that since we are imposing a condition, therefore, whether this is available in public domain. Let my learned friend show today that it is on public domain, I'll withdraw my petition. Today,
But you got it from Google.
I got it from Google price. I quoted. My tender is rejected because somebody else quoted 89.16.
That Google website you got it from is what
Of course,
website?
even now we can see, my lord. Just now we can try and find out what is the rate.
IOC.
But it is not available on as they would like to contain, my lord. So minimum
So
price. must-
they either they have an official website,
Yes.
separate official website,
Separate.
where they can show the
Daily.
daily.
So, my lord, therefore, my cause has been prejudiced. So, my tender has been rejected only on the ground. I quoted minimum that is 89.49, which was reflected in the Google. For example, my lord, today. Can you see the, my lord, today's rate in different petrol pump and the diesel price of as per their website. This is today's rate is 91.21. And kindly see the other one, my lord, the in different petrol pumps.
Astha Energy is where?
No, my lord, kindly come to the serial number 2 and 3, my lord.
Lohit and Lohit is same.
Lohit is same. Kindly see, my lord. Today the rate is 91.22.
21.
22. Lohit, yes, 91.21. Then kindly come to my lord Relimek. Number 3.
Yes.
Relimek is 91.22 and Damani is, my lord, 91.54.
Damani.
Yes.
And what about this Astha? Where is this
Well,
Astha?
this is different. It's code, is it? In the Shivsagar, my lord. And there also it is 91.54.
Now supposing we find that you have got a case. Now what is the next step?
Next step, my lord, they will have to redo the financial bidding again. Or they will have to issue the fresh tender, my lord. Or they will have to fix the rate. Whatever they have done, my lord.
Yes, now they have to fix the rate. Then.
Fix the rate and issue a tender. They cannot play around.
What
like
is
this.
the official rate on that?
Yes, on that, on the opening day. It can be 3-4 rates, my lord.
Correct.
Now, whatever that they have done to cater to the needs of the employees, the factory, all right, done. But you please issue a new NIP, as you did earlier. That's my humble submission.
Yes.
If that is so, my lord, I will not place my contempt.
Mr. Sailawala, just before you start off, just one query. Is there any official website that you have where you make daily updates of your?
Yes, my
Let
lord.
us see that.
My lord, I'm giving, my lord. In my affidavit, my lord, I have said, my lord, but here, if your lawsuit come to, my lord, uh, uh, paragraph 9,
Page?
paragraph 9, page 7. My lord, it is, petition opposition, my lord, paragraph 15, page 303.
303,
303. Your lawsuits may just,
para 15.
paragraph, my lord, you have given a bit.
Yes.
Which I got the expense of my, I'm speaking 5 days. Answering the opponent denies the complaint application lodged by the petitioner on so and so was filed in terms of law 38.1 by NIT as incorrectly averred by petitioner. In this context, it is worth to mention here that the petitioner filed application dated so and so has uploaded the document information showing 89.49 agency debt on PBO debt on 6th in Sibsagar district by claiming that the said debt was declared by IOCL on the website on PBO on 6/23 in Sibsagar district and had requested to consider the said HST debt for evaluation of the bids after price bid opening. It may be stated here that subsequently another request was received from other participating bidders requesting to fairly evaluate the price bids that have already been submitted by all the bidders, taking into account the possible HST that was in effect in Sibsagar IOCL report, as reflected in the official IOC application called Indian Oil 1 as technical bid opening date, which was on 6/3/23. It is stated that in order to confirm whether IOCL officially declares their rate for Sibsagar on official website, respondent decided to send a communication to IOCL on the same. Accordingly, mail communication was exchanged with the IOCL marketing.
No, this affidavit is by whom?
ONC, my lord.
ONGC?
Yes.
Okay, yes.
Yes. Accordingly, mail communication was exchanged with IOCL and marketing representative seeking details whether IOCL declares HST rate for Sibsagar in public domain, like on their website, on the internet, on daily basis or not. URL of the said website and HST rate on 6/3/23 for Sibsagar by the emails number so and so. In the response to above emails, by the email dated so and so, IOCL marketing representative informed that HST rate as on 6/3/23 was 89.616 per liter as per the records for Sibsagar town. And they also confirmed that all the rates for a retail outlet are declared overnight. Yet HST rate declared by IOCL at Sibsagar as on 6/3/23 was 89.16, which is also clear from Annexure 5, that is page 137 of the read petition. The partner to mention that hearing that above response of the IOCL and Annexure 5 the read petition, the respondent ONC had observed that HST rate as on 6/3/23 was 89.16 per liter as per the records for Sibsagar town. After getting confirmation from IOCL, they declared the rates which is outlet wise overnight. And respondent further tried to confirm whether rates declared by IOCL retail outlet wise were available in public domain on their official website or not. In the official website, IOCL is showing petrol. The following information are found. Daily price changes for petrol diesel are effected at 6 AM every day. Prices may vary from outlet to outlet within a city, town, sales area. Download Indian Oil, one mobile application on your smartphone to locate your nearest Indian petrol pump and check fuel prices. Now, this is the,
Was this in the tender, this Indian Oil one?
my lord. No.
How will they know?
Not the tender, my lord. It is, they have to get the, I'm coming, my lord. Here, what is, my lord, what is their case? If your lawsuit see, my lord, by misleading this court, actually, they have obtained from interim order. Your lawsuit, if your lawsuit comes to, my lord,
No. Where is the official website? What is the name of the official website?
no, not official, my lord, this is, this one app mobile. One app mobile, my lord, they declare the rate.
Where is it in the public? Where is
Yes, my lord, the public domain, my lord.
Let my learned friend show
where?
from his telephone.
Show,
Yes,
let us see.
Yes.
One app mobile app, my lord, it can be downloaded anywhere, my lord.
Where have you stated in the tender
Ah.
that the rates provided in the one app mobile?
No, that
And
In the Indian one.
not that my your lawsuit, my lord, I shall say, my lord, the all the he's a my lord, regular my lord, submitting the tenders, my lord. I shall show how he my lord, this is Melapidi, I'm just coming up. Your lordship may just see what he has said in para 9, page 7.
Okay, one thing before you all start, I just want to clarify.
Yes,
You see, this document.
Yes.
At 375,
yes. My lord.
page 375.
Yes, my lord.
Why is it not in your affidavit?
Well, that is not the question, my lord. We have submitted it earlier, my lord.
Huh?
We submitted it earlier.
Where?
Here at the time of
Huh?
in the motion, my lord. We submitted earlier. In the, my lord, that is not a question, my lord. Now.
No, this court is asking you. It's not a
Yes.
question of whether they are asking you. This court
Well-
is asking you, why have you not put this document in your affidavit earlier?
Yeah, admit, it may not be, my lord. But at the time of, my lord, the motion, I have submitted this document.
At time of motion, you submitted this document.
And moreover, my lord, I'm submitting, my lord.
Let me see if the court has recorded that.
The court has not recorded anything, my lord. Court has done, my lord, and your losses may just come from the petitioner petition. What is the petition, my lord? Because I'm submitting that your losses may just come to para 9
Of the
petition.
writ petition.
Para 9, page 7 of the
Page?
page 9, page 7, para 9.
Page 7, para 9.
There are petitioner begs to state that there are different HSD filling stations belonging to IOC in district of Sibsagar, Assam. Before submitting it under the papers, petitioner has quoted HSD rate according to terms of the contract document. Pertinent to mention that HSD rate of the IOC was shown to be 89.9 per liter in the website of the IOC. My lord, this is not correct, my lord. Now, my lord, you're also see on what basis he has obtained the interview. He said that in the website of the IOC, we got this rate 89.9. My lord, no petrol depot will sell the oil at lesser price, my lord, including my lord. Which was still reflecting in the said website even after submission of the registration by the petitioner on 28/8/23. But surprisingly, the said depth
The
on the website IOC,
in the website of IOC.
yes, was found to be absent after submission of the aforesaid declaration by the petitioner. This illegal act was done on the awarding contract of supplying vehicles to some employed contractors. Now, para, my lord, your lordship may see para 22, page 17. Para 22, page 17. Same thing, my lord. Same thing, my lord. Yes, yes, my lord. The fifth line, the glaring aspect will noted into effect after submission of request on 28/8/23. Seen that HST depth of IOC at 89.9 per liter is related from the official website of IOC. He is clear, my lord, his case is clear that in the official website of IOC. Now, if your lordship will see the, my lord, reply, his reply, that, my lord, page 357, para 4.
357.
357, para 4, please.
Yes.
As regards the statement made in para 6 of the affidavit of opposition, the answering opponent denies the correctness of same and instead of taking para 9 of registration, being fact supported by documents collected online from Google search, which with the query diesel price today at Sibsagar. My lord, there are many, my lord, oil companies, my lord. First, he said the IOC, letter 60, therefore, abandonment of Sunatu is stating that there are 9 registrations being erroneous, incorrect. So now, my lord, what he said, it is collected from Google, not from IOC website. He himself says. Now, I shall come to further, my lord. My lord, your lordship has already seen, my lord, the petrol depot rate, my lord, at page 239.
239.
Yes.
Yes,
It is 89.16.
yes.
Now, next, 240, my lord. Your lordship,
Just a minute.
it is 89.17.
Yes,
Then, my lord, 237, my lord, it is 89.49 because this is a distance, my lord, distance wise, my lord,
37.
89.49. My lord, distance wise, my lord, the rate changes. But the basic rate, my lord, declared by the IOC is also. Now,
No, Mr. Counsel.
now I am coming, my lord.
No. One thing. Basic rate, the basic rate will remain the same.
Same.
But depending upon the petrol pump, it will change.
Yes.
The selling price may change.
Change.
But where do we get the basic price
Basic
from?
price, my lord, that is what I am saying. Now, your losses may just see, my lord, whether he knows or not. Page 282. Page 282, what he has quoted, my lord. This is the tender. Opening date is 26/9/23.
Yes.
The tenders, my lord, quoted 2893, so and so, so and so. Now, item number 6, Mahmood Ali, the petitioner, he has quoted 29.04.
Yes.
The same tenderer, my lord, same tenderer quoted another rate if your losses comes to my affidavit, my lord.
Now this is with regard to which place?
This is this tender. In this
Some other
tender.
tender.
In this tender.
Some other tender.
For sure.
This tender. No, this is from-
Yes. Yes, my lord. This is water tanker.
How can it be?
When price is 89, how can I quote 29, my lord?
That's what.
No. This is the, my lord, running charge.
Correct.
Running charge.
So then what is his rate then? What is his rate?
This
You
rate
can-
this is, my lord, 29.04.
How can it be 2904 when the cost of diesel itself is 89?
Diesel, my lord, 1 liter, it runs 7 kilometers. It runs.
How many kilometers suppose it depends upon the truck also.
No, my lord.
It depends on the various factors.
My lord, I feel lost.
No. How do you connect this?
This is the rate, my lord, quoted by him.
Huh?
This is the rate quoted by him. This is the price chart, my lord.
Just let me see. The tender is what date?
Tender, my lord, submission is that.
Where is the tender? Page 28, correct?
Yes.
Page 28. Tender 23003.
My lord, if your lordship will.
Yes, it seems that it pertains to the same tender
No,
notice.
no, my lord, my learned friend is trying to, my lord, kindly come to the fifth column.
Yes,
How? Kindly see, my lord, running charge without GST, mine is highest, 24.61.
yes,
And without running charge with
With
GST,
GST?
29.04.
yes.
Yes. My lord,
Calculation.
calculation. And
So
para-
it pertains to the same tender.
yes,
That's what.
So his tender was not rejected. He was not the
my lord,
first tender.
my lord, let me come to it. When we multiply 0.275 into 89.70, then it comes to, my lord, 240. So then it comes to this pay, rate of really make, my lord. So this figure is arrived at by multiplying, my lord.
Correct.
That-
Correct.
No, my lord, my learned friend should be very candid to this honorable court. I'm sorry to interrupt, my lord. Please come to order dated 4/10/23 of the learned single judge of this court.
I'm coming, my lord.
No, please. I have taken permission from the court.
Yes,
4/10/23, my lord, please come to para 4 of the order.
yes.
This specific query was put to my learned friend, till that he has not answered. Mr. Sahela Lanet, senior counsel, appearing for the respondent ONGC authorities has submitted that on 12/9/23, respondent ONGC authorities made a communication to IOCL seeking information as to whether IOCL declares their HSD rate for Silsagar in public domain, like on their official website or internet or daily basis or not. Information was further sought from IOCL authority seeking confirmation as to whether they update their HSD rate for Silsagar on daily basis on their official website, and if yes, to provide URL of the said website. Sahela has drawn attention to the email dated 39/23 received from IOCL authorities, wherein it is mentioned that HSD rate as on 6/3 was 89.16 per liter. As the response received from the IOCL on 13/9 does not prima facie give the information reply with specific query made by ONGC authorities as on so and so, whether IOCL declares the HSD rate for Shivsagar in public domain on daily basis, let this case be listed again on so and so in order to enable Sahela to obtain this. This is the query which a lordship posing today. Same query was posed to him.
My lord.
So his answer to that
Yes.
is that Indian Oil One, the app, Indian Oil One,
Let them show
is
That there is an, my lord, all that is.
so the question is whether that app, the Indian Oil One, can
That
be
is
set,
available in public domain.
Yes,
and whether it is a URL or whatever.
my lord, I'm coming, my lord. Now if you also see, my lord, the same person, he has quoted the
Now we
date
have
of-
got to speak to someone who is tech savvy.
My lord. Now, if you also see the same contractor, my lord, he quoted 29.04 for the bid opening date of 26/9/23. Now, if you also see, my lord, my activity opposition, my lord, at page 340, right, 340. He has submitted another bid, my lord, which is to be opened on next day. My lord, you can also see.
9.49. 60. Yes.
Yes.
Your losses got it 340, my lord.
Yes.
Here, your losses on the left hand side will find bid opening price bid is 27.9.
340, 340.
340. On the top, my lord, left hand side, if your losses
The
find
date of opening of price bid 27/9.
27.920. That was 26.923
Ah.
and this is 27.923.
Ah.
What bid he has quoted, your losses see? I can now read. Well, absolutely, my lord.
No, what do you want to show?
He saw, my lord, his bid was 28.93.
So,
On the, my lord, one bid, my lord, previous day, my lord, opening bid, he submitted 29.04. Next day, he submitted 28.93.
it will depend upon the diesel price.
Yeah,
Let
my
us see.
lord, that case-
No, we will leave it that aside. We'll just go for this date.
My lord, I'm submitting why,
6/3/23.
my lord, this is, my lord, because see, two bids are there. In one bid, my lord, he has quoted 29.04, which is open on 26/9/23. And another bid, my lord, for water tanker, this is 27/9/23. There he has quoted 28.93. my lord.
So how does it matter?
Well, it matters, my lord.
How?
It matters because he knows everything, my lord. Your losses seen in the three depot, he has quoted, he got the rate of three rates. He pick up the highest rate to just make a profit, my lord. If your losses are seen that it is in Rohit service,
No, maybe you see, he's taking it, maybe he's taking advantage of the loophole, but if it's a valid,
not to fall, my lord.
if it's a valid,
My lord, all the bidders has
shortcut
collected
that
the,
he can take, how does it matter?
my lord, all other bidders has collected this rate.
No, their rates also are not in conformity. They're all quoting different. One is quoting,
My lord, your
one is
losses-
quoting 89.16, one is
No,
quoting
yeah, my lord.
89.17.
maximum is your losses see 28.93. My lord, they have quoted 3,
Not that, Mr.
4 to 6. Nine.
The question is very simple.
Ah.
The question is
Hmm.
whether there is an official website.
Yes, my lord. No, official, my lord, this is app, my lord.
And app
mobile app.
was created by whom?
IOC, my lord.
IOC.
Yes,
For the IOC.
IOC.
For
They-
or for
anybody-
everyone.
All petrol depot, my lord, they see with their rate, my lord, in the app. All petrol depots see that rate, my lord, the official. That is the official, my lord. All petrol depot see at 6 AM what the rate of that day in Ipsagar. That is the, my lord. That is official.
So that is your case.
That-
So your case is that they have got to see the app and they've got to apply the app. That's all.
Literally, my lord, that has to be done because everybody, my lord, the other Well, dealers have done it, my lord, other.
But then why did Damani service station give
Daman
89
is outside, my lord. Daman is outside, that is why his rate is, my lord, carrying charge is more. But my lord, nobody sells the diesel at a lower rate than the declared by a oil company. Because the basic rate which is declared, that has to be, my lord, they have to see. So nobody will,
His rate is higher.
my lord,
His rate is higher.
higher, but Lohit service has shown his rate as 89.16, my lord. So why he will sell the oil at a lesser price than the declared by IOC? My lord, your losses, some justification must be there, my lord, because the money is outside, my lord, it is outside the.
No, but out here they are asking for water tankers, not for petroleum tankers.
No,
only.
no, water tanker. So rate, my lord, whether it is there or not, because all the petrol depot see the rates in the one app mobile.
No, the issue is basically
Yes,
they have submitted the rate
Yes.
on the basis of Google, that's what they say.
but that is.
But
that's
that
not-
is
not
wrong
correct.
according to you, because as per the writ petition, they have said that they have done it as per the IOC.
IOC and replacement also same thing. Replacement also they have said.
And Google
Yes.
doesn't mention whether it is IOC
Yes.
petrol
Yes, man.
or diesel.
That-
Yeah. So that is what they say.
In the replacement also, your losses must see, my lord. Everywhere they have said the IOC. In the replacement at page 274, my lord.
Yes, sir.
Page 275. Page 275.
So there are two aspects to this case.
Yes.
One is that in your writ petition, you all have taken the stand that the rates have been quoted on the basis of the rates shown in the website of the IOC.
IOC. And that is in the replacement also, 276.
Today, just now, my lord, I've checked up, my lord.
Ah,
Today, diesel price in Guwahati stands at 90.64. This is what is available, nothing else. Let my learned friend show.
in which one? In this
Today, in today.
Indian oil one.
Yes, IOCL rate. Today,
Indian oil one.
yes.
You have taken this app.
Yes, just now, not app, my lord. I've gone to Google to find
no,
out
no,
what is
not
the
Google.
IOCL rate.
He's
No, my lord,
saying-
therefore, I am saying, Lordship has posed a very
Then-
pertinent question. Please show the website which is available for public consumption. That's all.
So
I
now-
said, my lord, if my learned friend can show, I withdraw my petition.
So he's saying
Ah,
that Indian oil one,
yes.
that is the website.
Oh, my lord.
Yes.
I'm not saying on that day, Indian oil rate was not 89.16. I'm not saying that.
I know.
I'm a tenderer, my
Ah.
lord. I access Google. Google says 89.49.
One mobile application.
I checked up from 3 different petrol pumps. I found they're all are different. So since the stipulation in the tender is rate should not be less than 0.275 into IOCL rate for Sipsagar, that's why I quoted 89 point. Now this figure of 24.61, it is arrived at after multiplying, my lord, 0.275 into 89.49.
So it could not have been lesser in any event.
So now it so happened that that rate is higher. I have now, all people have quoted at the rate of 18, some people have quoted at 89.16. They have got the work. Please come to page 281 of the writ petition, my lord. I'll show.
281 is
That's the, my lord.
type copy.
Yes.
It's a type of.
Kindly see, my lord, serial number 6 is the petitioner Mahmood Ali. His rate is without
Higher.
GST 24.61
24.61.
per liter. So this is arrived at by multiplying 0.275 into 89.49. So if I quote rate less than that rate, then my tender will be cancelled. But they themselves were conscious of the fact, whether it is in public domain, that page they have not annexed to their affidavit.
No, okay, now just a minute. Where is the calculation? At page 177.
Yes.
Basic running rate per kilometer should not be less than.
Not
So,
less than.
so you see, when it is 0.275,
Hmm.
into 89.49, which is higher than all the other persons. It cannot be less.
It is not less. So he tender has not been rejected, but he is not lowest.
Okay.
He is not the lowest.
That's not the issue, my lord.
I have not rejected their tender.
Let them show the ground of rejection. Rejection is
we have
because
not
I have
rejected.
quoted.
We have not rejected his tender.
Reject-
We are selecting the lowest rate,
Okay, so your
L1.
case is that
L1.
you took the L1.
No, no, my lord, I do not
And
make
he,
a-
according to him, his technical bid was rejected.
Then my learned friend is making a double-edged sword argument. Then in which case all other tenders should be rejected. That is
Correct.
because that is less than 89.49. In which case all other tenders should be rejected, my
No, no.
tender should be accepted. My under have not understood the clause itself. Not less than the IOCL rate. So 29, sorry, my lord. This other rates, these are all less than 89.49.
Yeah.
So those bids should have been rejected.
No, no, no. The thing is that.
No, he says,
uh,
my lord, no, my lord, tender condition is, it should not be less than the,
should not be less.
less than. So the, all other rates are less than the IOCL rate of 89.49.
No, that is, yeah, but we'd have to see what was the rate there and that date.
No, so that's the question. Ultimately, it boils down.
What
to
was
say,
the rate? What was the rate on
they
that
say
date?
it is
89.16.
89.16.
89.16, which is in the one of the petrol depot, my lord. My lord, no petrol depot will sell oil at a
It's
lesser
not that. What does the app, what does the record say?
Ah,
What
That
is
is
the official rate?
89.16.
My lord, why
Where-
a
where- from where
public
do you get that?
authority is taking such
From where do you
arbitrary
get
stand?
that?
Yes, I'm showing my lord. I'm showing.
No, anyway, someone who is a app, say, what is the difference between app and a URL?
One
No,
app mobile, my lord.
URL is the heady, na?
That is the my lord URL. One app mobile.
Uniform resource located.
No, that is the name. I understand what you really mean. Like, I understand
URL is
www
nothing
and
more than the that's some sort of an address, my lord.
URL is
That
the
means
address.
to identify that there needs to be something.
So an app cannot be a URL, can it be?
No.
Is an app a URL?
To trace the app, perhaps URL is required to access the app.
I don't know. Someone who knows the computers a little bit.
Anyway, my lord, the issue in this case is whether, my lord, when you are insisting on a particular condition to settle a public contract, then, my lord, people must know what is the rate of its own, at least through some medium where it is readily available. Today, my lord, the rate in Google and rate in IOCL could be different also. So, as a public member of public, I'll go to Google.
No, but then you are supposed to go to the official website.
Then, my lord, then URL would be required. Where
So
is
what-
it made,
so
where is it made public? It is public. No, my lord, their officials themselves say, it's not me I'm saying. Page 375, please see it once again. What is the view taken? 376. As per the discussion held in tender committee meeting on 7/9, indenter is requested to get the information from authorized representative IOCL that IOCL declares their HSD rate for Shivsagar in public domain, like
Okay,
on their official website or internet on daily basis.
let them file a small affidavit with regard to this.
Yes. No, I think it will be filed, it is filed by the IOCL, man.
But
Not by them.
IOCL is a party.
No, my, asset, not a party. Malad, all that I'm praying for is whatever you have,
Can you get some document from the IOCL with regard to this or what? Now what to do?
my lord can keep the matter for next Monday. Huh? We'll try. Or any other day convenient to launch it.
Or if you can impeach them
Yes, we can do that.
and we can direct them
Huh.
to clarify this issue.
Tomorrow we'll morning file it. Tomorrow we'll file it. Lordship may take up the matter at 2 o'clock, my lord, in the meantime. morning.
Just for impeachment.
Implement,
No, not for.
Yes, yes. Then we'll serve notice upon it. And I'll request the council for IOCL to appear.
Okay, right.
The only thing, my lord, we are suffering, my lord. because,
No, you are suffering, but I want some clarity on this issue.
yes.
That's all, not for any other thing.
Tomorrow, my lord,
My lord, nobody is
No, no,
suffering.
we are only
Despite
going to
interim
implead.
order, they have given the
You might not
contract.
be here.
Well.
We are only going to implead so that we can pass a direction to them
Huh.
to clarify this.
Yes.
Only thing, my lord, till then, we can make alternative management, my lord. Because,
No, no. You're
No, my lord, out of nine contract, they have already settled 7
you
contracts.
have,
no, out of
you,
seven, my
no,
lord.
no, there is you have violated the order
No,
of
no,
this
yes.
court.
my lord, because that order was passed, my lord, on the date.
No, no, sorry, Mr.
I
Saran.
should
I
come.
cannot,
I will come.
Right. Right, Mr. K. Chaudhary, learned senior counsel for the petitioner, as well as Mr. G. N. Sahewala, learned counsel for the state, for the respondent. Good stuff. The email issued by the ONGC to the IOCL has asked for information as to whether the IOCL declares their HSD rate for Sibsagar in the public domain, like on their official website, on internet, on daily basis or not.
Well, they have replied, my lord. We have annexed that. In the opinion.
Who has replied?
Every opposition, my lord, that I have shown.
Who has replied?
Ram, that is not there. That's why this problem is cropping up again and
Is it,
again.
is it replied by the IOCL?
Yes, ma'am. That page 322, my lord.
322.
Yes.
That is their version, my lord. This honorable court has posed that question.
322. What does it say?
My lord. That is the same, my lord.
No, no, that question was not answered, my lord.
At
Please
page
confirm.
325.
Huh?
Page 325, my lord.
325. Yes.
Download your Indian Oil One App mobile application on your smartphone to locate your nearest Indian Oil petrol depot pump and track fuel prices.
Now, how does this help? When the petrol pump,
This is not a
when the-
communication by IOCL.
and no, anyway, even if it is, how does this help? Because they are, when the Sibsagar petrol pump give different rates.
Yes.
My lord,
Anyway, right. As such, the IOCL would have to declare, would have to confirm as to whether they have any official website and the name of the official website with the URL. Looks
Exactly,
more, okay,
exactly.
with the URL should be indicated. Further, whether the HSG rate for Sibsagar is put up in their official website on a daily basis.
no, official, I'm not saying official.
No, no, this is the letter, not by me, this is the letter as
By
per the,
ONGC.
by ONGC,
Whom we
by
represent.
you.
Wait.
Uh, this is the matter.
Tomorrow, my lord.
This is the matter tomorrow.
We'll file it.
In the writ petition, the writ petition.
Deep look.
You put this on. Put this on, no? Get out of line.
Please, Lordship. Lordship, this is a contemplation, Lordship.
Madam, is it hit by a section 20 of the Contempts of Courts Act? What does the order say? What does the impugned order say?
Lordship, a repetition order was disposed of on 27 September 2022, Lordship.
To what effect?
Page number, it is on 23, Lordship. 22, Lordship.
So what is it? What does it say?
This is regarding the non-payment of,
What does it say, madam? What does it say?
Lordship may come to para number 3 on the last. Upon receipt of the amount
bills of the writ petitioner shall be processed and cleared within a further period of 45 days.
When does 45 days end?
But out of that amount, petitioner had received some amount.
Anyway,
On,
okay, right.
it is received on 10/5.
Heard, Miss, what is your name?
D. Angana.
D. Angana, Learned Counsel for the petitioner, who submits that the order dated 27/9/22 passed in WPC 4699/2021 has not been complied with. Issue notice returnable in 4 weeks. Petitioner will take steps for service of notice upon the respondents by registered post with AD within 3 days. This is the matter after 4 weeks.
My lord, item 4 and 8 be taken up together, my lord. Yeah, my lord, I have made a clarification, my lord. Lordship, kindly have a look at item number 8, page 52.
Yes,
52, my lord. 2B says, my lord, financial year. Average annual turnover of the bidder for financial year should be more than equal to fund, so should submit the authenticated copy of the income tax return, audited balance sheet and profit and loss account for last financial year.
So?
2021, 21-22 and 22-23.
so
So, my lord, last occasion, my learned brother has submitted, my lord, that in the, on 9/5/23, I became a medium.
correct.
Medium, he said, because, my lord, that is applicable will be 23-24. The moment 31st March cross, the financial year goes out. That will be 23-24.
No, that is a different thing. That is with regard to turnover. That is, the thing is whether at the time you were, at the time
No,
the
my lord,
NIT was
tender
issued.
says something, my lord. Tender says
Let us
only,
see the tender notice. What does it say?
tender says, my
What does
lord,
it say? Who can apply?
my lord.
Let us see. Your technical bid was disqualified, huh? Rejected.
My
Technical bid was
bid was-
rejected, correct?
I
Because he was,
Not
he did not submit the earnest money in terms of that clause.
clause E,
Clause,
your lordship clause. 4E, 4C.
4C. Which was not required for a small scale industry. 4C. other term.
4C. That will your lordship will see page 50.
No,
So my lord will see, my lord, one thing, my lord. Because terms and conditions of the NIT does not say on the day of tender, you should be small.
no. It just says that if you are small, you
Then
don't need,
only-
you do not need to submit your earnest money. That's all it says.
That is only, my lord. But my
But
lord,
you have not submitted,
yes,
but
my
you are not small.
23, my lord, they have asked only 22-23, my lord. Page 52.
No. Sorry.
Lordship will see, my lord, again, my lord. Page 52, they asked for 22-23, my lord. Nowhere they mention at the time of submitting, my lord, you should have.
Doesn't matter. Whether they wanted your turnover, that's all.
My lord, the moment 31st March
Mr.
cross,
J. Barbuya, learned counsel for the petition. Oh, huh? And item 4 also, item 8 also.
4 and 8 together.
Different orders, huh? Heard Mr. J. Barbuya, learned counsel for the petition. Also heard Mr. S. S. Roy, learned counsel for the respondent.
My submission should be recorded.
Huh? Yes, everything will be recorded. Mr. J. Barbuya, the learned counsel for the petitioner, submits that the petitioner participated in the tender notice dated 18/9/2023 for transporting postal mail bags in both postal mail bags.
Yes.
However, the petitioner's bid was disqualified at the technical evaluation stage due to non-submission of
Understood.
earnest money in terms of clause 4 bracket C of the NIT. No, next paragraph. Clause 4 bracket C of the NIT provides that micro and small enterprises registered under UDM registration and National Small Scale Industries Corporation are exempt from furnishing earnest money. Earnest money. Full stop. The petitioner's counsel submits that the petitioner. No, the petitioner's counsel submits that clause 2 bracket B of the NIT requires the bidders to provide the average annual turnover of the bidder for the last 3 financial years. Which should be more than or equal to 1,12,50,000. The bidder has to submit authenticated copies of income tax returns, audited balance sheet and profit and loss account for the last 3 financial years. That is 2020-21, 2021-22 and 2022-23 along with the technical bill. He submits that as the information required by the authorities in clause 2B of the NIT provided was with respect to the last 3 years as mentioned above, wherein the petitioner was a small scale industry, the petitioner was not required to submit earnest money.
So we'll see page 83, my lord, something section there, page 82 of item number.
There,
That is, my lord, my income tax return.
it's okay. What's up? He accordingly submits that the disqualification of the petitioner's technical bid at the technical evaluation stage, has to be set aside and the petitioner's financial bid should be opened. On the other hand, Mr. S.S. Roy, learned CGC submits that the petitioner at the time of submission of his tender was a medium enterprise and not a small scale enterprise. And as such, he could not have participated in the NIT without submission of earnest money. In this respect, he has referred to the
More date, my lord.
document which he has downloaded from the Government of India website, showing that the petitioner was a medium scale enterprise as on 9/5/2023, that is before the NIT dated 18/9/2023 was issued.
Of the financial year 23.
How does it matter? Accordingly, the petitioner, accordingly, there was no infirmity in disqualifying the petitioner's technical bid at the technical bid evaluation stage. First up, I have heard the learned counsels for the party. Clause 2 bracket B at page 52 and clause 4 bracket C provides as follows at page 54. A perusal of the above clauses show that a small scale enterprise is not required to deposit earnest money along with his bid documents.
Small and
The clause 2B requires information from the bidders for the period of 3 years, that is from 2020-21, 2021-22 and 2022-23. though the petitioner has tried to make out a case that because the information asked for the period stated above
Financially.
would determine whether the petitioner was a small scale industry at the time of submission of his bid, comma. This court is of the view that the clause 2B will, does not require, would not determine whether the petitioner was a small scale industry at the time of submission of his bid. Clause 2B only requires information for the period stated above. Just because the petitioner was a small scale industry during the above said period, comma, does not mean that he would continue to be considered to be a small scale industry at the time of submission of his bid above. Full stop. Next para. In the present case, comma, the document which has been downloaded, where is the document?
Master connection.
Oh no, this is not the one. Where is the document?
Lordship is kept on record. Lord. Extra detail. Notice of the-
Acha, this one I understand. No, this is not the one.
Yes, Lordship, yes.
No, this is the one.
Yes. No date.
In the present case, comma, the petitioner has submitted the Udyam registration number of the petitioner, which is Udyam UDYAM, dash AS dash 03 dash 0000 470, showing that the petitioner has been classified as a medium scale enterprise with effect from, where's that date? With effect from 9/5/2023. The tender notice, the NIT in the present case has been issued on 18/9/2023. As such, the requirement of submitting an earnest money by the petitioner. No, was required of the petitioner. Was required of the petitioner. As he was a medium scale enterprise at the time of submission of his tender documents. Next para. This court, by the last order dated 29/2/2024, had also given time to the petitioner's counsel to obtain instructions with regard to the document produced by the respondent's counsel with regard to whether the same was a fabricated document or not. However, however, no submission has been made by the petitioner's counsel that the document showing that the petitioner has been classified as a medium scale industry on 9/5/23 is a fabricated document. As such, the same has to be deemed to be correct document. In view of the fact that the petitioner was required to have submitted earnest money being a medium scale industry. The disqualification of the petitioner's bid at the technical bid evaluation stage by the respondents cannot be faulted. Accordingly, there be no, accordingly, in view of the reasons stated above, the writ petition stands dismissed. And then in the other, that will be in item 4, huh, madam?
Item 8.
In
my
item
lord,
8,
Impugn order, the work order, I challenge.
Huh?
Work order granted during pendency of the case that I challenge. my lord.
okay, then in the item, that is item 4 you challenge. Item 8,
4, my lord, technical bill,
technical bid.
that is correct. And
Item 4, item 8,
8 is, my lord,
that is the item 4. Item 4, okay, the item 8, what have you
item
challenged?
8, my lord, also can add, my lord, the work order issued in favor of the private respondent.
Okay, the out here is right, huh? Then right out here. Once at the bottom you write. Out here you are there, I think. Mr. UK Goswami is there, huh? Instead of Mr. Roy, Mr. UK Goswami, you just write. The petitioner. Now, consequently, the challenge made by the petitioner to the issuance of the work order to the respondent number
6.
6. Pursuant to the NIT dated, same,
Same.
the NIT dated 89/23 fails, inasmuch as the Supreme Court in the case of Raunak International Limited versus IVR Enterprise, I think, 1999 census, has held that has held at para 27. Yes, okay, then.
Sir, my lord, in item number 5, copy has not been given to Indian Water.
Forget copy. Where's your land document?
Yes, my lord, we have filed an additional affidavit also to file that. Now the Panchayat has, my lord, settled the Barghat without jurisdiction because
Huh?
without jurisdiction, my lord.
Where's the additional document?
Yes,
Additional affidavit.
Additional affidavit has been filed on, my lord.
Okay, I've got
25.
it. He has not been given a copy of the
My lord,
petition.
not been served the copy.
You give a copy of the petition.
Well, I'll furnish. Let it be tomorrow, my lord. I'll furnish.
Not tomorrow, next week. Tomorrow, too many cases.
Let it be Monday, my lord.
Wednesday.
Monday.
Wednesday. It's too many. Correct. I know.
So, let us receive the copy from
Let me see whether it is whether this matter can be decided here. I don't know.
Now, both the IW and the concert has no jurisdiction because of the, my lord, our High Court's decision.
Okay, right. Mr.
under RB Goswami on behalf of Miss MD Bora.
RB Goswami on behalf of Ms. MD Bora, Learned Counsel for
IWT.
IWD. IWT
IWT, respondent number
T.
13. My lord.
submits that copy of the writ petition has not been provided to him. Mr. MU, Mr. MU Mandal submits that he will submit a copy of the writ petition during the course of the day. Accordingly, leave this matter on Wednesday. That is.
In 6.
Here, my lord, item number 6 and 7, my lord, similar matter, my lord. Here, my lord, the respondent number 1 to 3, my lord, has filed a affidavit today, my lord, a copy was served on me, my lord. Here, my lord, one, my lord, letter has been annexed, my lord, whereby it appears, my lord, I have been debarred for 2 years in participating in this tender, my lord. So on that count, my lord, I have to take instruction. May I pray for a short date, my lord? On that
Oh,
count, I take
urgently,
instruction.
the road is in, condition of the road is very bad, lordship.
Next,
So,
Monday or
maintenance
Tuesday,
is very much necessary. Lordship directed me to produce the record. Why the bid was annulled?
Just a minute.
I have filed affidavit also today.
So so the affidavit is not in the record.
Because today, Lordship, yesterday could not serve the.
Okay, okay.
So what I could not say,
No, let me file his reply.
no reply, what reply he will file.
Okay,
Lordship. He
okay,
has
no.
already been delivered for 2 years.
Okay,
He cannot
depart. So
participate.
he has to challenge that.
No, he had not challenged.
He has not challenged.
Yes,
So
challenge.
on that
Because
one, my lord, I have to take instruction, my lord, on Monday or Tuesday, my lord, shortly.
Show me your affidavit. You have given a copy.
yes,
You have been given a copy. Show me.
Lord-
Show me your copy, madam.
Lordship, I have copy.
Page 82, my lord, of the affidavit.
Yes.
And relevant person is at page 84, my lord. Page 84, my lord.
No. Give me the inner pagination.
Lordship, my lord, inner presentation, my
Inner petition, that is 84.
84, my lord.
No, 84 is this. Photo, there's no 84, this is 83. This is the last
That
83.
is the second case.
Huh?
This one is the first case. I have to do. Apart of the yes.
Page 84 is the relevant person, my lord. I have one from it. Further performance. Bottom, my lord, second. Further the performance security. Lordship, my lord.
You file an affidavit.
Lordship,
When?
next week, my lord.
When?
Next week, my lord, anytime, my lord.
No, Lordship, the condition of the road is very bad. Lordship, maintenance is urgently required in that area. So, Lordship, already Lordship has done the status quo. We cannot go ahead with the
Correct.
bidding process because he has been debarred. He cannot participate in this project.
And this
No,
letter.
madam. He's out here in this writ petition.
Lordship, he is misleading this honorable court, Lordship.
He's misleading.
Yes.
Not
He has
misleading, my
committed
lord.
fraud, Lordship. While he has participated in the bidding process, yes, he has been debarred for 2 years for participating
Just a
in.
minute. Issue was the order.
So he has not disclosed all these things.
Not, this fact was not disclosed to me, my lord, earlier, my lord, in the tenor of the tender, my lord.
The petition.
As,
Huh?
only today, my lord, I came to know about this letter.
Okay, he was debarred when?
23, my lord. 20/04/2023.
23,
20/04/2023.
2004.
2023.
And, okay,
So it will be effective.
and the NIT is of, then you cannot challenge. Your
Yes.
case is gone.
Lordship, my lord.
Up to
So on
25
that
years
count of
delivered.
only, my lord, I have to take instruction.
No instruction required. No,
Lordship,
no.
because
Any
it's
date.
down-
Heard Mr. K. Bora, learned counsel for the petition. And Miss
This is Arbor.
R. Bora for
For response number, NHIDC, Lordship,
NHIDC.
1, 2, 3, all the.
Respond number 1 to 3. The item 6. Then you just take para 1. Don't the para 1, last order. Don't put this heard, don't put heard. Just start with Miss K. Bora. So then para 2, para 3. Next, Miss K. Bora. The learned,
Arbor.
Arbora, the learned counsel for the respondents number 1 to 3. Submits that affidavit in a position has been filed today.
Yes.
And where is that debarment? What?
84, my lord.
Yes, 84.
84. And the petitioner, and the fact that the petitioner, where is that, page 84?
Page 84, my lord, of WBC 1033, my lord, affidavit, my lord. Page 84, my lord, second last paragraph from bottom, my lord.
84.
84, my lord. affidavit of opposition in by Lord WPC 1033, my lord.
What does it say?
Order the performance security and retention money submitted by the contractor shall be engaged in person to the clause substantial of the contract agreement. The contractor shall be debarred for a period of 2 years from participating in the
Okay, this is with regard to another tender.
lordship.
Another tender. Huh?
Another tender, my lord.
Manipur Lordship.
Okay,
Actually, they are
okay, what have I said?
for all NHIDC.
And that the petitioner had been debarred from participating in any future tenders for 2 years
For 2 years.
by letter dated 20/04/23 issued by the NHIDCL has been kept hidden from this court.
Yeah.
I have next, on perusing the letter inverted commas without prejudice, inverted commas close, dated, no, number NHIDCL/RO-Infal-R&R/1-K/KM 274.610 to KM 297.700/2022-23/05, dated 20/04/23, issued by the DGM bracket P,
Okay.
comma, RO Infal. Is to the following effect. Now, at para 12, 13 and 14 is to the following effect. Page 84, Next para. In view of next, on considering the letter inverted commas without prejudice, dated 20/04/23, which shows that the petitioner has been debarred from participating in any future bids of the NHIDCL. This court is of the view that the petitioner cannot have any enforceable right in this petition unless and until his debarment in terms of the above letter is lifted or set aside by this court. Accordingly, there being accordingly, in view of the reasons stated above, the writ petition stands dismissed.
Can I pay for only one day time, my lord, because I have no knowledge about, my lord, what is the fate of this letter, my lord. After this letter, my lord, whether I have challenged or not, my lord, that instruction.
Whether you have challenged or not, also unless the stage, you see, one thing is that you have kept this hidden from this
Only one
court.
date, my lord, may I pay, my lord, only one
No.
date.
Huh?
Only one date, my lord,
One date.
only one date.
Okay, tomorrow. Or you 2 o'clock. Till 2 o'clock, you give a phone call.
Lordship,
2 o'clock. Till 2 o'clock.
lordship,
Same order in the next case.
lordship.
But out here, wait, in the next case is 1035. Out here, where is it? The same letter, no?
Same Lordship.
Same letter.
Same letter.
Same thing.
What's it, the interim order maybe?
Huh? Yes, registry to put on record, to place on record the affidavit filed by the respondents number 1, 2, 3.
Interim order will be taken.
At 2 p.m.
Interim order stands vacated.
Problem.
That is, we are doing everything ready in advance,
Lordship.
believing her.
I have to inform and, my lord, take it.
Oh, yes, yes.
Because you see, and yes, you just see if there is some lifting of the order, if there is lifting and which she has not stated, then straight away stay.
Lordship, that must be.
2 o'clock.
All right.
Wait, your lordship. My lord, this is the matter wherein, my lord, we have challenged the decision of the decision of the bid evaluating committee for rejecting my technical bid on the ground that I have not submitted the financial soundness certificate
which according to the respondent is an essential document, but as per the NIT and claim of the petitioner, which is a non-essential document, because the NIT and the tender document stipulates that to be an additional document or an ancillary document, wherein your lordship was pleased to protect us by directing them to maintain a status quo in respect of the items that I was to
Yes,
supply.
madam.
Do
They
we
were-
send to file my rectification?
Okay, right. Miss
Arbora on behalf of B Chaudhary Lordship.
Ms. R. Bora on behalf of Mr. B. Chaudhary, learned counsel for
For the respondents agriculture.
all
department.
respondents,
Yes, Lordship.
for all the respondents. Please for 2 weeks time to file affidavit in the position, praise allowed. List the matter after 2 weeks. Interim order passed earlier shall continue till the next day.
I'm highly
Okay,
obliged, my lord. Deeply obliged.
Thank you, Lordship. The similar matter, Lordship, department is taking 2 weeks more time for the instruction, Lordship.
Only the
The other matters also,
Huh?
in other matters are also there in. the
It's
list.
a small matter. It's
Yeah.
only whether that Ma Enterprise, the GST number is that number that he has mentioned. That's all.
I think they need 2 weeks more time, Lordship.
In the minute, Lordship, just state the further proceeding.
Huh?
That work order may be state Lordship. Because in 2 weeks, Lordship, they will complete their work.
Correct. Right, Miss, what is your name?
Kotoki,
MM Kotaki, the learned counsel appearing on behalf of
Animal Husbandry and Veterinary Department. Respondent number 1, 2, 3, and 4.
praise for 2 weeks time to obtain instructions in the matter. Praise allowed. List the matter after 2 weeks in the interim. Work order already issued.
Lordship. To the respondent number 5, Lordship.
When? Work order issued when?
Month of
It was
December only,
31,
Lordship.
25th of January 24.
25th of January, so already 1.5 months. Already elapsed. I don't know what is the present status actually, Lordship.
You're not doing anything, then we stop. In the meantime, in the interim, in the interim, the impugned work order shall remain state.
Private respondent is present.
Oh, we have not issued notice.
Notice
No,
may go, Lordship, to
For the
respondent 5.
respondent number 5.
Okay, then we've got, wait. You had asked for adjournment on the last day.
Yes, Lordship.
On last.
Acha, because of those other matters.
Yes, Lordship. On
Okay,
last.
right. Heard Mr. J. Kalita, learned counsel for the petitioner, who submits that the petitioner, that the respondent, who submits that the respondent number 5 was issued work order by submitting one quotation from Ma Enterprise, MAA, having GSTN 9 number so and so. However, Ma Enterprise does not have the above said GST number. Stop. Issue notice returnable in 1 week. Or 2 weeks. But then he'll finish the work. He'll say that finished.
2 weeks, Lordship, as the instruction of the department.
Okay, 2 weeks. Ms. So and so accepts notice on behalf of the respondents number 1 to 4. Petitioner takes steps for service of notice on the respondent number 5 by registered post with AD within the course of the day. Full stop. List the matter on, give a date. On which date
27.
the respondents council shall obtain instructions till the next returnable date. The work order issued to the respondent number 5
Page number 40.
shall not be acted upon any further.
My name may be reflected, my name. is
Registry to reflect SC,
Standing Council, Animal Husbandry and.
animal husbandry and veterinary science in the cause list.
Because item number 36, 37, 38, 39, same issue. Lordship.
Or 30
36, 37, 38, 39,
or same order,
same order.
okay.
Side. 36, 37, 38, 39,
Obliged.
same order.
Huh?
Same.
Nothing will be changed. You take this, the numbers here, just see this number.
Lordship. No, right.
What is it? Just take it again.
11 and 12.
May keep it. Yes.
I have received the instruction, Lordship. Of
To what effect? Give them a copy of what?
Lord. So,
Yes, what is the instruction, madam?
Lordship, may kindly come to last para of first page.
Yes.
So here the train which is a passenger train, and so the BP remained attached. Regular detention of this train led to loss of punctuality of the train and inconvenience to the traveling passenger. As the leaseholder did not agree to pay extended freight on pro rata basis, railway incurred loss by running empty BP from Guwahati to Silchar. We have extended to Silchar, Lordship. Previously, it
Yes,
was
madam, that is your problem.
Lordship.
Your initial contract agreement is from that place to Guwahati only, not up to Silchar.
That is why
So,
we have
why-
asked him to continue up to Silchar,
Okay.
Lordship. But
Where-
when
where?
he, Lordship, we
No,
have
no, Silchar. Why should they continue to Silchar? They don't want Silchar.
that we are showing our difficulty why we could not
It- But you cannot force them. You cannot, see, supposing there is an agreement between you and him to do a certain thing, say, supply you one football every month. You cannot say that now you're going to supply me two footballs every month when there's already a subsisting contract between you two. If he doesn't want to supply, he will not supply. How can you force them?
and that is the reason, Lordship, why it's not possible within that very short time. We cannot detach that from Guwahati to Silchar. If we another tender was issued for that period, it was difficult because within a short period we cannot just add or deduct that portion of had
Then you think of some way to compensate.
and Lordship, we have even subsequently he also was supposed to continue with that, Lordship, and we are free to that also. Again, if he now also wanted to continue up to the extended part, Lordship, that he had showed his willingness.
If he
later
wanted,
on.
he can do it.
Lordship.
That depends
And
upon him.
more so, Lordship,
You file an affidavit. You file an affidavit.
and we have also, although we have given the notice on 17 to Lordship, but supposed to continue it from 2017 to 2020.
No. This.
One more thing that till that no third party. There is a, according to 33.2 also, Lordship, there is a provision. Although there is no breach of trust, Lordship, but that there is a provision that he can give us 2 months notice, and by giving 1 month notice, this contract can be terminated, Lordship.
Why should he doesn't want to terminate? Why should he? Why
Although
should
the
he?
breach
I
of-
have interest.
It's your problem. You have created the problem yourself.
No, my lord, I want to submit is that, my lord, page 62. The right to terminate is there, my lord.
Then you
because
terminate.
For whatever reason,
You terminate. We'll see.
accordingly, we have issued the show cause notice.
I will see. But then it has to be, you see, just because you have a right to terminate, doesn't mean that you can do away with Article 14. It
Yes,
has to be in terms of Article 14. That's
My lord,
all.
but the contract gives that discretion, my lord. It's a determinable contract, my lord.
Maybe determinable, but we'll see. Doesn't mean that just because it's determinable, it has to be a reasonable, it has to be on the basis of a reasonable explanation, not on a whims and fancies on something you might have forgotten. That is your problem. You have created the law for yourself. You go against that officer, tell him, why did you miss out on the Silchar extension part?
Ultimately, it's all for public interest, Lordship.
So what? It's not only public, there's a money also attached to it. Madam, you cannot extend it so far when it's you who has entered into a contract and agreed by the contract. What do you mean? It's not public interest. Okay, it's public interest, then pay him damages. Pay him. You have a fresh thing. Cannot be done so easily. Right, Miss, I heard Mr. S. not learned counsel for the petition. Miss S. Bora,
Be sure.
B. Sharma, learned counsel for the. You're who's appearing?
My lord,
I'm
11 and 12.
11,
I am in
he
12.
is 12.
Miss S. Bora, CGC, B. Sharma, learned counsel for the respondents. Submits that she'll file affidavit in a position within. This I'm not accepting. within 2 weeks. List the matter after 2 weeks. The interim order passed the day shall continue till the next day.
Item number 12, I'm the,
Then in the item 12, Miss M.
I'm Sharma.
So, and then it will be Mr. H. Gupta, same.
That's it, the interim order.
Interim order both continue till the next day. Same order. The common order. Is it two? Common order. No, two separate orders. Different causes, separate. H. Gupta will be for yes, 6 times.
And next week, Wednesday. Huh? Next week, we're open.
After 2 weeks, after 2 weeks.
But not the last week of March.
Acha, wait, we'll issue notice. Right, so, wait, instead of that, third Mr. So, asking for the petitioner, issue notice. Issue notice. Miss B. Sharma accept notice on behalf of all the respondents. Then, and 2 weeks time to file affidavit in opposition. Then, prayer allowed, so same thing, okay, same thing, only that. Here also issue notice, both issue notice. No. No case, there will-
Last order, Lordship 1/3/2024. We have disposed of the appeal, Lordship.
Yes, what has happened? Appeal this.
The items doesn't match, Lordship, that's why we have given a remarks, Lordship.
Your Lordship will see the disposal of the appeal. I have the copy. Your Lordship, the order has been issued by director. Your Lordship sees that.
Yes,
This is merely clarification of the finding of the departmental bid committee. The authority entrusted under section 38 have not passed any independent assessment and evaluation of my complaint. Your Lordship will see that. They have merely clarified as to what the departmental bid committee had clarified earlier, which is under challenge. If your Lordship will kindly come to page 132. Page 132 of the writ petition, your Lordship.
no, what is this matter about?
The matter, your Lordship, is that the tender pertains to supply of agro machineries and minor tools. There are certain quoted items which were supplied by the petitioner, by the supplier. Those did not match as to the items which are sought for by the employer. So they were rejected in the technical phase. Now, technical assessment was sought to happen in the month of August 2023. It happened on 22nd. The decision of the departmental bid committee
22nd of
February, after 6 months. It was conveyed to us on the Saturday on 24th. On the 26th, we preferred an appeal on the same day.
on what ground?
The fact that the grounds that the quoted items would match the specifications as sought for by the employer. That is our claim.
It matches.
It matches. That is our claim. That is a technical assessment, your Lordship. I'm not versed with the technicalities of the items, your Lordship. On the same day, without disposing of the appeal, they opened the price bids. The price bids now, your Lordship, has been stayed, the entire tender has been stayed by your Lordship pursuant to item number 9, I presume.
No, only the particular items. The tender-
Particular items in which the
tenders for
petition is.
Those items.
Now, after your Lordship had passed the earlier order in this writ petition, they sought to disguise the opinion of the departmental bid committee as the order of the appellate authority. There is no fresh order which has been passed. Under 38(2), assuming I do not cut through their specifications, assuming I do not make the cut, let it be, I do not make the cut. But I have to be afforded an opportunity of being heard by section 38(2). Section 38(2) has been referred to in the bid document also. But they have not followed the procedure laid down. And thereafter, the departmental bid committee's comment has been clarified as an order of the appellate committee.
You mean by way of this?
Yes, that does not,
Director has passed the order.
Huh?
The director of the horticulture has passed the
the
order.
director has not passed the order. He has merely
These
clarified the
items,
departmental bid committee's comment. Your Lordship would see that.
No, let us see the other, where is the departmental bid committee?
Yes, your Lordship will kindly come to page 132. Page 129, your Lordship.
Page 129 of the writ petition.
Yes,
Yes. Your lordship has come to 129, your lordship.
yes,
Yes. Your lordship sees the last item, the serial number 5, solar light trap 5W type A.
yes,
Yes. It has been rejected on the ground which has been laid down in the last column.
yes,
Experience of solar home lighting system, solar LED mass lighting system, solar photovoltaic pump system, which cannot be considered as experience of a particular item. This is the reasoning.
yes.
Now your lordship will see the order which they have passed, the appellate authority.
That has to be same lordship because it is on technicalities of the items lordship. We cannot change what is solar light there.
That cannot be a comment of the departmental bid committee. Departmental bid committee has already sat on the issue. Now my appeal is before the authority. It is.
No, so he has found, he has found it to be the same.
He
He's
has,
agreed.
he has only passed a remark for clarification. Now your lordship will kindly, your lordship has the Procurement Act supplied, furnished before your lordship on the last occasion. Now, it is not my claim that I be given the contract.
Then,
I be at least be given an opportunity of satisfying the authorities on on technical ground. I understand that your lordship and me, we might not be technically versed in the matter. At least I be given that because they have already opened it.
but where does it require that you should be heard personally?
Yes,
Where does
your
it say
lordship,
that?
the order, there's the act which has been provided before your lordship.
Yes,
Yes, yes. Now, your lordship, before your lordship comes to the act, your lordship will kindly come to page 33 of the writ petition. Your lordship will read both the documents together.
33,
Page 33, your lordship.
yes,
Bidders who seek to appeal against any decision, action, or omission regarding this particular procurement may do so as per section 38 of the Assam Public Procurement Act of 17 and Rule 26 of the Assam Public Procurement Rules of 2020. Now, your lordship will kindly take up the act.
yes.
Yes, yes.
And his appeal was just a letter to the director lordship. That is my first page of my instruction lordship. His appeal was just a letter to the director.
Now, your lordship will see. Now, I'll satisfy this. I'll satisfy this. 38-2.
Now let us see your appeal first. Where is
Yes.
your appeal?
The first page of my instruction lordship.
What page of the instruction?
Just now I placed it.
Page 136, your lordship. There is no format for an appeal which has been laid down. This is in fact, the finding of the departmental bid committee was communicated to me on 24th. On 26th, your lordship sees, I prefer this representation or an appeal before the authority under the act, under the department, the document. Now, under the act, it is given, the section reads that on receipt of an appeal under subsection 1, the officer designated under that subsection shall, after affording a reasonable opportunity of being heard to the parties, determine as to whether or not the procuring entity has complied with the provisions of this act, the rules and guidelines made thereunder.
Where are you reading?
Your lordship, page 1053 of the act. 1053 of the act.
Yes,
Yes, section 38-2.
ah,
On receipt of an appeal under subsection 1,
okay.
your lordship.
So let it be heard.
And since the tender is already under stay, the item number 9, so hearing me and giving me an opportunity will not prejudice the
Notice may
case.
be issued lordship, I'll file my affidavit lordship. Because in the earlier case, it was status quo was maintained only in regard to those machineries lordship.
It's not with regard to his case.
No, there was the entire
And
process
their
was stayed.
grounds of rejection were different. They couldn't
No, you
provide
see,
the-
no, see,
But
that,
in this case, lordship, we couldn't.
No, no,
provide us
madam,
with The technical
madam,
machineries lordship.
madam, one thing. The thing here, like you said, both of you are saying, you see, this is with regard to technical matters, which we have got no clue.
Yes, that is my purpose.
Now, since there is already, he has taken the alternative route, efficacious alternative route, statutory route, or whatever you may call it. As per this, there is the first appellate authority and the second appellate authority. Now, according to you, the first appellate authority has taken a decision. Only thing is that the first appellate authority has not taken a decision after giving him an opportunity of being heard. So he wants an opportunity of being heard.
Yes, yes, sir.
So we will set aside this order, let him go back to the director, and director takes a decision. And thereafter, if he still agrees, he can avail of the second appellate authority.
Yes.
End of the matter. Why should we keep this pending?
In fact, subject to what a lordship finally determines, the order, the instructions which my learned senior has produced before this honorable court, in my humble submission, that is piggybacking on the earlier order which is already under challenge.
I'm not on that.
No, since I just might.
But that is,
Yes,
we won't go into that issue.
yes.
Right, heard Mr.
M. Sharma.
M. Sharma, learned counsel for the petition, as well as Miss
Arbora for all the respondents.
Arbara for all the respondents. The petitioner's grievance is that his technical bid has been disqualified.
Yes.
At the technical bid evaluation stage. And that the appeal preferred by him before the Director of Horticulture and Food Processing has been disposed of without giving an opportunity of hearing to the petition. Full stop. Right. Next para. The petitioner's case is that he participated in a tender process pursuant to tender notice dated
29/7/2023. It's a page 19 year old, page 27 year old. Page 27.
tender notice dated
29/7/2023.
29/7/2023.
Yes.
For the invert commas parallel rate contract of agro machineries and minor tools for the year 2023-24 and 2024-25. This is at page 32. However, the petitioner's technical bid was disqualified on the ground that the items to be supplied by the petitioner
Do not match.
was not as per the specifications laid down by the respondent. The petitioner thereafter submitted an appeal dated 26/2/2024 to the Director of Horticulture and Food Processing Assam in terms of section 38
2.
bracket 2.
Yes.
No, 38,
Section 38. Yes, of the public.
38 of the Assam Public Procurement Act, 2017, hereinafter referred to as the 2017 Act. The petitioner's initial grievance was that the said appeal has not been disposed of by the appellate authority. Ms. Arbora, the learned counsel for the respondents, has submitted the letter dated 1/3/2020, the letter dated 1/3/2024, issued by the Director Horticulture and Food Processing, Assam, to the petitioner. Wherein what does it say?
It doesn't say your
The
lordship.
specification of the items doesn't match, not true, what we wanted.
Wherein it appears to show that the items to be supplied by the petitioner are not compatible in terms of the specifications provided
Eligibility criteria of the bid.
by the respondent.
Sorry to interrupt your lordship. The second last column says finding of the bid evaluation committee.
He's relying on the redevaluation committee's finding.
No,
It's not there.
what is wrong? He can rely.
But he
what-
can rely, but what he has done is he has just clarified that finding. He has not provided an independent finding
What's
as
up?
sought for under the act.
Next para.
Yes.
The petitioner's counsel submits that the disposal of the appeal by the director is cryptic and is only a clarification of the finding made by the bid evaluation committee. No independent finding has been made by the first appellate authority. And there is no final decision stated in the impugned letter dated, 1/3/2024, showing that the petitioner's appeal has been rejected. Correct?
Yeah.
Full stop. He also submits that in terms of section 38(2) of the 2017 Act, the petitioner has to be given an opportunity of being heard, which was not done in the present case. Next, Ms. R. Bora, learned counsel for the respondent, submits that the petitioner's appeal has been rejected by the director, though it has not been specifically stated so in the said letter. She however fairly admits that in terms of section 38(2) of the 2017 Act, an opportunity of hearing has to be provided to the appellant / writ petitioner. I have heard the learned counsel for the parties. The letter dated 1/3/2024 issued by the Director of Horticulture and Food Processing, disposing of the petitioner's appeal, is cryptic and does not have any findings and does not contain any findings of the appellate authority. No final decision has been made has also been made in the said letter. Full stop. The above being said, the next para, next para. The above being said, para 38(2) of the 2017 Act provides as follows. Well, as it appears that the appellate authority has not considered the case of they have not given an opportunity of hearing to the petitioners.
Petitioner, one
Petitioner, this court is of the view that the appeal of the petitioner should be reheard by the director and decided after giving an opportunity of hearing to the petition. Consequently, the letter dated 1/3/2024 issued by the Director of Horticulture and Food Processing is hereby set aside. The Director of Horticulture and Food Processing is directed to dispose of the petitioner's appeal dated 26/2/2024 after giving an opportunity of hearing to the petition. The same should be concluded within a period of 2 weeks. 2 weeks from today. That's all. That's all.
That's all.
These petitions accordingly disposed of. Before disposal, the letter dated 1/3/2024 issued by the Director of Horticulture and Food Processing is made a part of the record and marked as an Annexure X.
The Lordship can kindly record my senior's name, Your Lordship. I'll be grateful for that.
Why? He's not here. What is his senior's name? MK Chaudhary. He's not here.
I'll leave it here.
I'm good.
All right, sir.
May I please vote?
Petitioner with the Lordship is an SAS agent.
This certificates is issued by the district administration. And he is attached to the Guwahati GPO, Lordship.
No, what was cancelled?
Yes, Lordship,
Huh?
it is proposed by the senior postmaster GPO to the district deputy commissioner to cancel and terminate my license, Lordship. What happened, Lordship, regarding to joint accounts between the same parties, some dispute arose. And an inquiry was made by the Anmajar police as per the request of the this GP of Guwahati. Now this report, after that a report has been submitted, page 16 Lordship is the report of the police that may I please read second paragraph. During the inquiry, it is found that one transaction has been done by the allowed alleged accused. The same sum of amount has credited back to the account number by the alleged suspect and found no has been done wrongful gain and wrongful loss has been occurrence during that transaction. No any ingredients of committing commercial offence have been found. Therefore, it is found that there is no any wrongful gain or loss have been occurrence during the transaction. It is dated Lordship 1/2/2024. But before receiving this report, Lordship, Senior Postmaster on 9/1/2024 issued the dispute letter requesting to terminate.
What are you doing? What work are you doing?
Is an agent, Lordship.
What
SAS
agent?
SAS, it is a standardized agency system under National Savings Organization attached to the post office GPO of Guwahati. These are licenses are issued by the district administration. Since 1997, I am doing this. And now it has been renewed up to 2026.
We'll see, let us, this, heard Mr.
SD Production.
SD Prakash and counsel for the petitioner who submit that the petitioner is aggrieved with the letter dated 9/1/2024 issued by the senior postmaster, Guwahati, to the deputy commissioner, Guwahati, requesting him to cancel the petitioner's license due to his involvement in some alleged fraudulent and suspicious transactions in the Guwahati GPO. Issue notice returnable in 4 weeks. Mr. S.S. Roy accepts notice on behalf of
Lordship, respondent number 1 and 6, my friend will appear. Rest I will take.
okay, Ms. V.A. Gayan accepts notice on behalf of respondents number 1 to 4.
1 and 6.
1 and 6.
1 and 6.
While Mr. S.S. Roy accepts notice on behalf of respondents number 2 to 5.
2 to 5.
This is the matter of the court.
Till then, Lordship, maybe because there is a report of the police. And it was
Yes, what to do?
Lordship, it was on the basis of, we have done on the basis of senior postmaster's report, Lordship. We have to take the instruction.
Can you obtain instruction by next week? Then we won't issue notice.
Yes.
Don't issue notice. Just say Miss A. Gayan appearing for 1 to 6, 1 and 6, and Miss S. Roy, Mr. S. Roy shall obtain instructions by the next day. List the matter on. Give next week date.
Okay.
The prayer for an interim stay shall be considered on the next day.
One extra copy may be
Extra.
done.
Extra copy.
Otherwise, you see, it is a report says it is as per their request. GD entry is there.
It can always be stayed. Don't worry. We just want to know.
By this time, if any action is taken, then
Then we'll see that document. Because we do not know everything.
yes. I also do not know everything. But report is there, police report is there. Actually. Item 50.
Or we allow the stay.
Lordship, let it after the instruction. What was the? I am insisting, Lordship, because of this police report, Lordship. It clearly says if I am whether
But there might be some other thing
other
also.
things also. Lordship. Let it be our.
Till
then, Lordship, then it can be.
Which we did.
30. When is it? Item 50.
Miss KK Chaudhary. You know how to do it. You don't need me, no? Can be done. Appears for petitioner, Miss, yeah, for
For water resources,
name.
Miss A Lodha.
Miss A Loda appears for Water Resource Department. Miss A Gayan appears for respondent number 1. That's all. Okay, done. Just a minute. Attach here. Miss, just a minute. And Miss A Loda. A
A Lodha, LODH.
Lodha. So the first amount is 7,20,000. It is here. Okay, how many you made yesterday? Next.
Similar matter.
Just a minute, I have to change the name. A Lodha. Out here it is 6,33,000. Oh, it's there. Correct.
70.
Yes, what is your case?
We are selected as highest bidders, my lord, in open competitive bid, my lord. And we are settled with
Highest bidder.
highest bidder, and we are settled with the respective mining contract area for such area.
For mining sand over.
Mining contract area for my lord, expecting minor mineral, that is my lord, sand, gravel, art, etc. And what happened, my lord? At the time of participation, we have deposited earnest money, that is 10% of the reserve price, and 25% security, my lord, after selection, my lord. Now we are operating in our respective mining contract area, my lord. And during this period, my lord, some persons, they are extracting minor mineral within our mining contract area and, my lord, in the nearby area, without my lord, work permits. And, my lord, respondent authorities are issuing work permits without any competitive bid to some persons of their choice. And they were, my lord, granted mining permits in nominal, my lord, nominal deposits, my lord, which in comparison to our, my lord, security deposit, earnest money, etc. So, my lord, we have submitted our representation to the DFO, my lord, Divisional Forest Officers, to stop such issuing, my lord, illegal permits without competitive bid, my lord. And what happened, my lord, in some specific urgent time, my lord, the department may issue work permit to some contractors, my lord. But without such emergent situation, my lord, such permits are issuing, my lord. And our submission is that, my lord, they may issue such permits, but when our all mining contracts are available, my lord, or can settle with us, they may collect same minerals from us also, my lord. And we have to pay, my lord, regular installments, which is also a huge amount. If other persons are extracting minor minerals by way of permits or without permits, my lord, then our business is seriously prejudiced, my lord.
That's not the issue. The issue is whether, you see, whether they're giving it to others also, that's not your business. They're giving, unlucky. You file a PIL. Unless if they're mining in your area and you want to pay a
Within
company,
our area also.
who is doing it?
My lord, those are some persons who we
Where
can.
have you written to them that
Yes,
they're
and
doing it
we have
in your
submitted
area? Where?
representation, my lord. Those are dear, my lord.
Yes, where?
Your lordship may kindly see page
Page-
33.
With the-
Yes. Annexure 7, my lord, we have.
Mr. Council, this is, you see, they're allowing mining in an area next to your area.
My lord.
There is nothing out here.
But, my lord, we offered our contract price on the basis of feasibility, considering the, my lord, quantity they have quoted in the tender, my lord, NIT, my lord, and my lord, distance between other my lord mining contract area. Because we have offered highest price, my lord, on the basis of that. If my lord government allows
Yes,
other,
what is to be done?
lord, sir, I'll have to get.
We'll issue notice, that's all. All right. All right, mister.
UK does.
You can ask the counsel for the petitioner who submits that the petitioner has been settled with the NKB 10 Bardanga mining contract area for a period of 7 years.
Madam.
That is to end in 2029.
My lord.
So he submits
My
that
lord, yeah,
while the just a minute, submit that while the petitioner is paying a very high revenue for mining the said area, comma, the foreign authorities have allowed mining and given permits in the nearby areas of the petitioner's mining area, comma, thereby for which the petitioner is incurring huge loss. Issue notice returnable in 4 weeks. Mr.
I bought it.
I bought Thakur access notice on your response number
1 to 7.
Huh?
1 to 7.
1 to 7. Anybody else?
I put written back.
Mr. S.S. Roy access notice on behalf of respondents number 8 and 9. List the matter after 4 weeks.
My lord, yeah, we have 4 petitions of my lord, and there are my lord 5 my lord mining contract area.
No, just give me the 4. Then you file for it for file petition. That cannot be.
File my lord 40 separate.
This is not a PIL. Sorry. That is there. How many? I thought there's only one person. Oh, there's 4 and 5 different mining areas.
Yes. Ma'am. And we have 5
No,
separate.
I'm dismissing it. You file 5. Otherwise, you go PIL.
My lord,
There's no case in that case.
but my lord, earlier my lord.
Then your case is different. That means 5 of you have been paying revenue
Yes, ma'am.
on different settlements.
Yes, ma'am. And
Like third,
I have paid my lord separate 40 for separate my
Huh?
lord. 40 also paid separately.
Mr. Counsel, if it's a different cause of action, you've got to file separate writ petition, not
My
one
lord,
writ petition.
cause of action is same. My lord, illegal mining, my lord.
Then you go PIL.
My lord,
I'm
then
dismissing.
I may be allowed to withdraw my lord. I will file separate petition.
You go in PIL, I think better. Mr. UK asked Learned Counsel for the petitioner. Praise that he may be allowed to withdraw the writ petition with lead party to file a fresh. Mr.
I got
I about Thakur appears for
responded 1 to 7.
1 to 7. Mr. S.S. Roy appears for 8 and 9. The petition counsel is allowed. The writ petition dismissed as withdrawn from with liberty as paid for.
Item 18.
I think your lordship. Your lordship, this petition is pertaining to the non-payment of the contractual bills of the petitioner, your lordship.
Where is the admission?
Yes, you admitted, your
Where?
lordship, the completion certificates are annexed.
Completion certificate is not an admission, Mr. Counsel. Completion certificate is not an admission.
The status report has also been annexed.
Huh?
The status report about the completion of the work, your lordship, has also been.
Status report and you see, Mr. Counsel, supposing you complete construction of a building, say for 1 crore, does it mean that the government owes you 1 crore? They might have given you money in between also.
The bill has also been issued, your lordship.
So where is the admission? As per Tamsher Ali's case, the full bench of the Guwahati High Court has said that it has to be an admitted amount.
Bill has been issued by the secretary of the block development office, your lordship. All the bills are annexed, your lordship. At this stage, your lordship, at least notice has been issued, your lordship.
There are other alternative remedies. If this is not an admitted amount, this writ court cannot decide.
Lordship, let them,
Where is your representation to them to pay?
your lordship, he verbally he opposed the.
Verbally, no, you go, think, right. You cannot just come like that and ask for a roving inquiry to be done. You might have a legitimate claim, but then our hands are tied also. Supreme Court has said in so many cases. We try to understand and accommodate it.
I may be allowed to take the instruction whether you have submitted any representation, your lordship, different representation.
No, where is the admission? Where is your RTI? Ask them, where is the admission?
Yes, sir. Lordship, here in this case, Lordship may have-
Where is the admission? No need of giving me completion certificate. Where is the admission by the state respondent that they have, that this much is admitted amount?
Yes, Lordship. Admissions are there, Lordship, but
Where?
here, Lordship, we have not annexed, Lordship, as because, Lordship, those documents were given to me, Lordship, unofficially.
That's a lie. Anyway, I'm dismissing it.
Lordship,
Third
may-
mistake.
Lordship, may
I am
kindly,
Ahmed, learned counsel for the
Lordship,
petition.
I'm having the documents, Lordship, here, Lordship. I'm having the documents,
Yeah,
Lordship.
why is it not in the writ
That's
petition?
because, Lordship, those
You
documents.
keep it with
Lordship,
you.
those documents, Lordship, were not, I have not obtained through Lordship proper channel, Lordship. Lordship, may I humbly create that, Lordship, may kindly fix this matter at 2, Lordship. I'm having those documents, Lordship.
No.
Even, Lordship, in a similar case, Lordship, notice was already issued, Lordship. I'm not. on that,
Sometimes we are issuing it, but then it's becoming a habit. You have got, when
Lordship. One more
was,
time, Lordship, I am sitting.
when was
Admission
the,
is there, Lordship.
when was the work completed?
2021, Lordship, March 2021.
When were you last paid?
Lordship, when the, Lordship, here, Lordship, there were 3 heads of payment.
When were you last paid?
2021. Lordship, page number 80, Lordship. This is the letter of.
When, which month? Which month?
Lordship, March. Total estimated amount so and so.
We'll take it up at
already
2.
paid.
We'll take it up at 2.
Yes, Lordship. Highly obliged.
Maybe the lordship. Lordship, kindly pass over the matter for the day. My senior has left the.
Huh?
My senior has left the lordship due to some emergency.
Due to?
Due to some family problem, lordship. Pass over the matter for the day, lordship. Like,
On the prayer for adjournment made on behalf of the petitioner's counsel, list the matter after a week.
Yeah, please, the lordship.
Where is the admission?
Yes, lordship, that would be. Lordship, in general, I'll just take one line.
No, where is the admission?
Lordship, page 36, annexure 11. There are multiple letters which are.
Huh?
There are multiple letters. I'm bringing one particular.
No, you just give me one.
Page 36, annexure 11. That's a letter from the deputy commissioner to the commissioner and secretary, wherein the second para. If your lordship allows me, I'll just read forward. As per the report of the ex-engineer, the contractor had already received 71.
Yes. There seems to be admission there.
Such part payment has been made.
Then,
Yes, the balance amount is yet to be paid. That would be 8 lakhs, 68,052.
Deputy Commissioner paid for it.
No.
right,
No, not,
petitioner's counsel prays that. No, Mr.
TR Sen, lordship.
Yes, what do you want now? You notice, we issue notice? Yes.
Yes, sir.
Mr. T.R. Sen,
TR Sen.
learned counsel for the petitioner submit that the additional deputy commissioner bracket DM, Barpita, letter dated 4/2/2021, addressed to the deputy secretary to the government of Assam, revenue and DM, bracket general department, is for a request to release rupees 8,68,052 for the additional work done by the petitioner in respect of the SDRF scheme. bracket, repair and maintenance of SPT bridge number 7/1 on Kojarpit, Suharpur, Karma, Gatirbori Road under SDRF for the year 2016-17. Page 37. It is there, huh? Issue notice returnable in 4 weeks, Mr.
SR Borwa for response number 4 and 5.
SR Barwa accept notice on their response number 4 and 5, while Miss S. Sharma accept notice on their response number
6, 7, 8 and 9.
2, 6, 7, 8, and 9. Mr. Chalia, you're there? No. Okay, this is the matter. After 4 weeks to enable the respondents council to obtain instructions.
Much obliged.
This case I am approved by the corrigendum document issued by the Excel Department of it.
Huh?
I am agreed by corrigendum lawsuit regarding the last date of submission of tender lawsuit. Your lawsuit may kindly
Page
look at page 33 lawsuit clause 9 lawsuit.
33.
Lawsuit the first have page 20. That is the EB lawsuit.
No, you see, don't tell me a page, just tell me what is the issue?
Lawsuit issue is that lawsuit.
You took part in the tender,
Yes, I
process.
have participated in the process.
then
I was disqualified.
disqualified in the bid stage, technical bid stage.
Technical bit state process.
Then so you are agreed with that?
Not.
No, you're not agreed with that.
Not exactly with that. Lordship, what happened, Lordship? The last date of submission was on 17/1
So,
and that was extended.
ah,
And that extension corrigendum was supposed to be uploaded online. But that was manually issued, Lordship. At page 63, Lordship. And that is done by the superintendent of excise. But where the bid documents say that it can be done by the district collector only. Because he is the issuing authority.
okay, tell me one thing.
Okay.
The extension was made by 1 day or 2 days or what?
Only one day, Lordship.
So instead of
Extended.
17/1, 23 or 24?
23 Lordship at the
23.
2024.
So it became 18/1, 24.
24.
And has the license been given, granted to somebody,
No,
allotted?
the price bid has not yet been opened, Lordship.
No. So you're not challenging your disqualification.
Yes, Lordship.
You're only
Along with
challenging.
that, I have also challenged the disqualification, Lordship, but the thing is that they have violated the conditions of the bid document, Lordship.
How?
Lordship,
Because instead of the DC, the superintendent.
Lordship may kindly pay us page 33, Lordship. Clause 9.
Yes,
Response to pre-bid queries and issue of corrigendum, Lordship.
yes.
District collector in consultation with excise commissioner may issue addendum corrigendum at its sole discretion, which is considered reasonable by it. Any such addendum corrigendum issued shall be made available in the portal assam-tenders.government.in. District collector shall not be under any obligation to entertain response to suggestions made or to incorporate modifications sought for. That can be done only by the district collector in consultation with the excise commissioner. And also at page,
So was any correction made?
yes, that date was extended, Lordship.
Date was extended. Now, how does it prejudice you?
Lordship, if on that day, Lordship, my bid was disqualified because I did not submit the police verification report. On that day, the report was ready, Lordship. But they hastily proposed to close that bid on 17/1, Lordship. But thereafter, they extended the date. On that day, 17/1, they hastily closed that bid.
Earlier,
Submission.
as per the NIT, what is the last date of submission?
17/1, Lordship,
17/1,
at
So-
5 p.m.
5 p.m. So you submitted your bid at 17/1, 5
Yes.
p.m.
Yes,
So what prejudice is caused to you by extension by a day?
my bid was disqualified because that police verification report was not there. But on that day, it was ready, Lordship. I could not submit it because I
So-
has,
So why didn't you submit it the next day?
no, that was not allowed, Lordship. I was not allowed.
Or you say that this So you're not allowed?
Yes, Lordship. To resubmit the bid, Lordship, on
Okay.
extended.
So yes. He's saying that he wanted to submit on 18-1, not allowed to submit. That is your case.
Yes,
He has not made any representation to that extent to us. This is the first time he's saying it. And in fact, apart from the police verification report, which he did not submit at all, even there was a requirement for submission of the APDCL no due certificate. Even that has not been submitted.
yes, that up to that receipt was submitted, Lordship.
So I have
Up to that,
specific instructions. And he has not produced it. If he had that document, he could have produced it.
No, let us see the reasons for disqualification of his technical bit.
Yes, Your Lordship.
at page, Lordship,
At page
66, Lordship. List of ineligible bidders in technical evaluation, therefore is that number 1. Ground of rejection, Lordship.
Daffodil. Your name is Daffodil.
Therefore is that.
You're smiling. Okay. No, so APD. So not given.
APDCL clearance certificate, but against APDCL clearance certificate,
You gave your
the up to that payment receipt, Lord.
you gave your
Up to that payment receipt. APDCL up to that payment receipt. That was submitted.
I have
Yes.
this bid here because I could.
no. One thing is this. You see that APDCL clearance certificate. Is it a essential condition of contract?
We have, it was because if we have to relax it, Your Lordship, we have to relax it for everybody.
Naturally.
That it was not done, Your Lordship.
But in another case, you have done it.
It was another district, Your Lordship. So this is a district wise.
So what? So what?
No,
what do you
because the
So
deputy.
in one district it is black, in another district it is white.
No, that cannot be, what I'm saying, Your Lordship, is that since it is a district wise tender process,
But what is the objective for having a APDCL
Yes,
clearance
what
certificate?
happens is, as per the supply code, Your Lordship, if there are outstanding dues on a particular
It's only
property,
to see whether he regularly pays his dues or
it
not.
shifts to the new owner.
Correct. No, whatever it is. So it is to see whether he pays his dues or not.
Yes.
So if he has paid it, how does it matter?
No, because he has not produced any document, Your Lordship.
Up to that receipt was there.
I have his
Not
bid
there, not there.
and specific instructions.
Okay, so that is not there.
And the police verification
He
certificate.
did not, but yes, so police certificate, this police verification report,
He
why
has
did you
submitted a
submit?
document. He has submitted a document, but Lordship may kindly have a look at the document he has submitted.
Okay, within the time limit.
Within the time limit, he has submitted a document which was not acceptable to us.
Oh.
And this is what is usually submitted.
So this is all.
This is what he has submitted. And this is usually police verification report has to talk about his criminal antecedents, whether he has anything.
So this is what you submitted.
Regarding
Police.
that was ready on 17th, but I could not submit. This is the police.
This is for some other bidder. I'm just producing it for Your Lordship. That this is what everybody else has submitted.
No, that's okay.
Yes.
Outside there's nothing.
There is nothing, Your Lordship.
That was otherwise ready. If I get that opportunity on 18th, I could have.
Did you ask?
Yes, I verbally made a prayer, Lordship.
Huh?
Verbally made a prayer that I may be allowed to submit on 18th.
When was your bid disqualified? When was the bid evaluation done?
14th of February.
14th of February.
This year.
This month,
14th of February.
last month.
It was uploaded online.
And the last date of submission of the bid was
On 17/1, that was extended.
17 or 24.
Yes,
Extended on 18.
18.
But that was known to you.
Lordship,
That extension was known to you
later on, Lordship.
later on.
Later on, I can do.
Later on.
I
So
did not. If I have already known about that, I did not hastily file it on 17 laws. And that was not uploaded as required by the Act and rule. That was supposed to be uploaded online. That was not done. Only this manual.
should be the act and rules.
Section 23 of the Act, Lordship,
Page
page 1042, Lord.
104.
That is not the annex, Lordship. Act,
Yeah,
act,
Have you typed it out or something?
sorry, Lordship.
Only you're going to have the book.
Yes. Procurement. Public.
Only one thing is this this APDCL clearance, you did not, the receipt, electric bill receipt you paid.
Yes, sir.
Where is that?
Let him show it from this. This is his tender. This is what.
Yes, do it.
to us by the department.
Let us see if it's there. If it's there, you might have a case. If it's not there, you might not have a case.
Because it was not there in the petition also. So this is what he has submitted.
Where is it? Where is the clause that says that the APDCL no clearance, no due certificate is
Is
required?
at page number 30 here.
Clause 6 to 18.
6.2.18,
And the police?
6.2.20.
What do you say with regard to the extension that has to be done by the deputy commissioner?
Yes, I have specific written instructions, Your Lordship, that it was done with the approval of the deputy commissioner.
Let me see, let me see.
Is it there? You're right. Heard Mr. Debarment, Senate counsel for the petitioner, who submits that the petitioner's financial good in pursuance to the grant of India made foreign liquor bracket IMFL retail off license. Which had been pursued by the petitioner in terms of the notice inviting e-bid bracket NIB dated 14/12/2023 should be open, comma, after the disqualification of the petitioner's technical bid by the state respondent is set aside. This paragraph. The petitioner's case is that pursuant to a NIB dated 14/12/2023, the petitioner applied for grant of IMFL retail off license. Of license for where? At Laukwa Road, Naugong Municipal Board, Naugong. However, the petitioner's technical bid was disqualified on the ground that the petitioner, where is that?
It is at page
Page 30, I think.
Page 19, you're simplified.
On the ground that, on the
Ground is at page, Lordship,
page 66, Your Lordship.
66.
on the ground that the petitioner had not submitted proper police verification report in terms of clause 6.2.20 of the NIT and APDCL clearance certificate in terms of clause 6.2.18 of the NIT. Next paragraph. The further grievance of the petition is that the last date of submission of tender in terms of the NIB was 17/1/2023, which had been extended to 18/1/23 by the
24.
superintendent.
24.
24.
24, which had been extended by the superintendent of excise and not by the concerned deputy commissioner. Mr. K.P. Pathak, learned counsel for the excise department. On the other hand, submit that the extension of the last date of submission of documents in terms of the NIB from 17/1/24 to 18/1/24 had been done by the superintendent of excise after due approval has been taken from the concerned district collector. In this regard, he has submitted letter number NXE -2023/2024/PT-1 dated 6/3/2024 issued by the superintendent of excise Bonani Hojai, Nagaon.
Her name is Bonani.
Oh. Superintendent of excise, Hojai. No.
Superintendent of excise,
Excise,
Nagaon.
No. Hojai is her name.
Bonani Hojai is
Bonani Hojai. Okay. He also submits that he also submits that the petitioner did not submit any no dues electricity certificate from the APDCL, nor did he submit any did not submit any electrical payment receipts, which is bid amount, which is bid documents. He further submits that the police verification report was not proper. He accordingly submits that the petition should be dismissed as there is no infirmity with the disqualification of the petitioner's technical bid. Yes, is it there?
Because
As per my instruction, it is there, Rasid.
As per the bid document, it is there.
One more thing, Rasid. It was supposed to be uploaded online. Whether that was done on that day or later on, Rasid, that cannot be a certain, Rasid.
No, Mr. Counsel, whether you uploaded or not, you will know,
No, not my documents. What corrigendum they did, that was supposed to be uploaded online, Rasid. As per the clauses, 2 and 3 clauses that is mentioned, that is to be done online. That was manually done, Rasid.
What was manually done?
That,
The corrigendum.
yes, that's corrigendum.
Corrigendum is only with regard to the last date.
Whatever it is, Lordship, any correction, any corrigendum, any modification, that is to be uploaded online, Lordship. Was it 9/11?
So it was not done online.
Yes, not.
But how does it prejudice you?
Lordship, I was waiting for that 18/1 result, Lordship. The technical bid open date was on 18, Lordship. And if I get that opportunity on 18, then I could have supplied all these documents, because on 17/1 my police report was ready.
Okay. So assuming, police report we agree. Okay. We allow, say. But what about the no dues certificate?
As per my instruction, that was submitted, Lordship. Whether it is available with.
He says no, it is not. There's a disputed question of fact.
this is the instruction I have received.
So, Lordship, I may be allowed to take instructions then.
One aspect, Your Lordship, because he's saying that he could have submitted a document, he had it with him on 17. He submitted his bid on 17 January 2024 at 4:25 PM.
Yes.
So till 4:25, we definitely did not have the document, Your Lordship.
On 17/1, that was.
But I have that. If he had it with him on 17/1,
Office hours is up to 4:30. It was issued on 17/1, Lordship.
This is the.
This police report is of 31/24.
No losses. That was uploaded of 31. Date is on 71.
No, this is perhaps the one which I had produced as reference. This is something.
This is different. This is not there.
This is, I just produced as sample, you know.
What is this?
This is the e-bid summary where.
No, that police verification report. Where is the police verification report? This one,
17 one. No, sir.
17 one. But you did not have it.
No, on that day, I did have this one, 17 one.
But you could have some. When did you get it? When was this given to you?
On 17 one.
When? 1 o'clock? 10 o'clock?
That instruction I'll have to take lordship. But as per my
He submitted his bid when?
At 4:25.
4:25 PM. lordship.
Okay, this right. Mr. KB Pathak further submits that the petitioner submitted his bid on when? 4:25.
4:25
PM.
On 17.
On 17/1/2024. And at that relevant time, he could not have had the police report, which he is now trying to, which he now says he would have submitted if he had known that the last date of submission of bids had been extended to 18/1/2020. In the petitioner's counsel, just right? Now petitioner's counsel further submits that if the petitioner had known that the last date of submission of bids had been extended up to 18/1/2024, the petitioner could have submitted the proper police report dated 17/1/2024. Next paragraph. Now you will say that you got it on 5 or 5 o'clock or 6 o'clock. That is 100% guarantee.
Okay.
You have to say that. So even if I give you time, you are going to say that you got it after 4 or 5 o'clock. 5 after 5 o'clock.
This copy lordship. I'll have to take instruction. I don't have that.
No, that's 100% your client will tell you.
But my instruction is.
I'm
that-
telling you, 100% the client will tell you that much. You won't tell him, your client will tell you that.
Okay.
Anyway, give him one chance.
Okay.
Very good. On the prayer of the petitioner's counsel, this is the matter in the next sheet.
But right.
Difficult, highly difficult.
Right, please. Dear my lord, after this letter, my lord, I have finally represented before the authority, my lord, and that is still pending, my lord. And subsequent to the letter also, my lord, I was allotted with a similar letter of work, my lord. One work I have mentioned in my repetition, my lord, that is.
Doesn't matter, Mr. Dev. That's a different issue.
My death submission may be. recorded, my lord.
Okay, okay. Who took that? You took that. Okay, just right. The petitioner's counsel submits that subsequent to the debarment of the petitioner from participating in any tender works for a period of 2 years, the petitioner has submitted a representation against the same to the concerned authorities. However, the same has not been decided by the authorities till date. You also submit that the petitioner has taken part in other tender works thereafter. Anyway, that's all. Full stop, dismissed.
Right.
Same thing.
Obliged.
Item 18.
Same. Okay, different. What is this matter?
This honorable court was pleased to inquire about the admission part of it. May I please that document?
Lordship, may kindly come to clause number 2.
Two,
Clause number 2, Lordship.
clause number 2, yes.
Total wages amount already been paid to the job card holder, 2,58,156. Total material bills already paid to the vendor against the above mentioned rupees 5,000. Grand total 2,63,156. Next, Lordship. Now being to be paid wages bill nil. Now being to be paid of material bill 1,54,134. This is to be paid, Lordship.
Okay. Yes, you cannot put this here.
Say, he admitted that it's unofficial document, so.
That's why I'm issuing notice only.
Yes, Lordship.
No, I'm not. You obtain instructions.
Yes, Lordship.
He's having difficulty.
Yes, Lordship. And Lordship, if they dispute, Lordship, then I don't have any case, Lordship. And that is admitted position. Lordship.
Because from here, I can understand his anxiety. He cannot produce this.
Yes.
Right, heard, Mr.
M. Ahmed.
M. Ahmed, learned counsel for the petitioner, who submits that the petitioner's unpaid bills amounting to rupees
43 lakhs.
43. How come 43? Out here is only 160. How can
Lordship, as much as Lordship, 15 bills at the end, Lordship.
same person
Same person. Small amount, Lordship.
amounting to rupees 48,70,760.34 has not been paid. Issue notice returnable in 4 weeks. Miss
And Bora,
N. Bora accepts notice on behalf of
correspondent number 124567.
14567. Mr.
As a Bora for number 3.
Please the matter after 4 weeks.
Registrations.
Do this matter.
May take back the document. High level.
Yes.
That is matter, Lordship, regarding refixation of land, that is matter.
Huh?
Refixation of that land, Lordship.
Representative is
They have not annexed that documents, Lordship, that agreement, that's clause 23 part.
So what is to be done?
Representative, let them come up with all the documents, including the documents, agreement, etc. Otherwise, Lordship cannot adjudicate the matter. Last day, Lordship, day before yesterday, that matter, Lordship, regarding clause 23.
my main given.
Clause 23 regarding?
Regarding in clause 23, day before yesterday, matter, Lordship, regarding refixation due to encroachment, some land strings, Lordship, similar to that.
No, my lord, my main grievance is that I was
Oh, here, his case out here is different.
different, Lordship.
His case out here is, he was supposed to be given possession
Yes.
sometime in, when?
1/4.
April, first April. He was given possession in December. So he wants remission of that period.
251 days, Lordship. That representation is pending, Lordship. Page 19.
So,
Let me take instruction, Lordship, let it fix on Monday, Lordship.
okay, Mr.
MK Hussain.
M.K. Hussain, learned counsel for the petitioner, submits that the mean mahal had been settled with the petitioner for 7 years from 2022 to 23 to 2028 to 29. Full stop. Though possession of the fishery was to be handed over on 1/4/22, the same was handed over only on 8/12/22. Full stop. The petitioner has thus prayed for remission of the
Refund of money, Lordship. Adjustment.
has paid for
Adjustment of money.
adjustment of the money payable by the petitioner for 251 days due to the late possession given to the petitioner. Mr. P. Sharma appearing for the AFDC. Says that he may be given time to obtain instructions. This is the matter when is it?
That's for number one.
Huh?
One is also written.
One is also
One is also unnecessary. That's fine.
FDC. No one appears for the petition on call. The matter pertains to cancellation of the FPS license issued to the petitioner. Full stop. Thereafter, the appeal filed by the petitioner was also rejected. Full stop. A perusal of the petition appears to show that there is no procedural irregularity. Full stop. However, as no one appears for the petitioner, list the matter after a week.
Supplementary motion item 41.
My lord, may pass over the matter for some time, lordship. He's on list, lordship. He has some instruction, lordship.
Status matter, madam.
After some time,
So,
42.
I didn't get this file.
May I please?
No, it's okay. This is for this.
May I please?
Yes,
Because subsequent to a notice inviting tender, the petitioner submitted his bid and he was the lowest bidder. Letter of intent was issued in his favor. And all of a sudden, without informing the petitioner, the LOI has been cancelled. The petitioner came to know from the GEM website. He accordingly filed a representation to inquire about the status of his bid. Thereafter, he was informed that his bid has been cancelled. And no reasons has been recorded, my lord. And now they have come up with a fresh NIT, wherefrom it appears that the petitioner will be ineligible to submit his bid.
where is that?
Lordship, that is the last annex, Lordship, page 63.
NIT dated?
Lordship, 11/3/24 is the bid end date.
Huh?
That is 1323, top right hand corner, Lord.
1-3?
13/24. Page 63, Lord.
1-3. But what is this page? Page 62. Annexure N. It's different.
Annexure, page 62.
Ah,
Annexure
this is
9.
the informing you. Huh?
Yes.
Okay. But where is, why can't you participate?
I cannot participate in this because Lordship will kindly see the technical specification at page 65.
Yes.
Lordship, brightness down below,
Yes.
brightness, minimum needs 500, 600 or higher. Lordship, this kind of tablets is manufactured in India only by Samsung Electronics Private Limited and no other OEM, that is original equipment manufacturer, manufactures this kind of tablets.
This 500, 600 or higher.
Yes,
brightness.
bids. And this 500, 600 bids are not required, Lordship. In the earlier bid, it was 250 only. And generally, as your Lordship knows.
Anyway, right, heard, Mr. Yes. You obtain instructions. Yes, heard, Mr. P. Bobby, learned counsel for the petitioner. Who petitioners who submits that the petitioner took part in the NIT.
Yes,
NIT dated
Lordship. An extra 4, Lordship. That is 11/12/23.
11/12/23 for supply of tablet PC with MDM software. Full stop. However, full stop. The petitioner was thereafter issued the letter of intent by the respondents on 21/2/2024. Full stop. The petitioner later came to learn that the letter of intent issued to the petitioner firm had been
Lordship, may I say something?
Ah.
The letter of intent is 16/2.
Letter of intent dated 16/2/2024 had been cancelled.
Yes.
Due to some reasons, inverted commas, due to some reasons. Void letter dated 21/2/2024. Full stop. And no, not full stop, and a new NIT dated 1/3/2024 has been issued for the same, for the supply of the same material. Article.
Computer tablet.
Computer tablets. Full stop. The petitioner's counsel submits that the specification regarding brightness of the computer tablet required in terms of the new NIT would bar the petitioner from participating in the same, as the said specification is made only by Samsung
Electronics India.
Samsung
Private-
Electronics
India Private Limited.
India Private Limited, and not by any other company.
Right.
Full stop. Issue notice returnable in 4 weeks. Or maybe in 3 weeks. 3 weeks. Mr. K. Gogoi accepts notice on behalf of
1 and 2, Lordship.
1 and 2, while Mr. B. Gogoi accepts notice on behalf of 3. List the matter after 3 weeks. In the full stop. On considering the fact that the petitioner had been issued the letter of intent dated 16/2/2024, and the cancellation of the same has been made due to some vague reason, that is inverted commas, due to some reason, inverted commas close, the petitioner has made out a case for an interim order. Full stop. Accordingly, the NIT, is the NIT? The NIT dated 1/3/2024. Bracket annexure 10. It's stayed. Till the next returnable date.
Can I pray for a statement regarding
Give a
supply
date.
of tablets to the school?
But what kind of reason? Due to some reason.
It's on is there, Lordship.
Huh?
Brightness of the dead screen is required 500 to 600. But Lordship,
That is not there in
that is
the.
not specifically mentioned here. Otherwise, it is the reason central government specification is that it should be 500 to 600. Lordship.
We'll see, you bring out those.
500 to 600, otherwise, Lordship, that is the reason. Lordship. We'll place.
3rd April.
Only-
The Study Council APDCL has received some additional instructions from Lordship. They are supposed to produce the instruction
This is item
25.
Yes. What is to be done? What do you want?
As I am informed, the instruction is to be waited by the 1 minute time is
Okay, Mr.
W. Ahmed.
Your name is not here.
No, W. Ahmed, on behalf of KP Path.
Miss KP Pathak, his name is, okay, Mr. W. Ahmed appearing on behalf of Mr. KP Pathak. SCAPDCL. Who submits that instructions are awaited. I'll list the matter after 2 weeks.
Obliged.
26.
Here also my lord instruction has been.
Same.
My lord, they are waiting for instruction since 22, my lord. Kindly see, my lord.
Since 2017.
2022.
Huh?
26, my lord, 2022. My lord, they are waiting for the instruction, my lord. Only thing is this, my lord, I have paid the amount, my lord. They under section 126, they raise a provisional bill, my lord. Against that, my lord, I file an appeal, my lord, under 127, my lord. My lord, the amount was reduced to 18,000, my lord. My lord, 18 lakhs, sorry, 18 lakhs, my lord. I paid the amount, my lord. And thereafter, after 2 years, my lord, they again served me a notice that with a disconnection notice that they pay another amount of 2 lakhs, otherwise your connection will be disconnected. Then, my lord, I approached this honorable court. This honorable court was pleased to, my lord, state that order, my lord. And, my lord, a criminal case was also filed against me, my lord. After, my lord, payment of the, my lord, money, my lord, whole amount, my lord. The criminal case was also, my lord, dropped, my lord, against me, my lord. Now, my lord, since 2022, they are waiting for this instruction.
Only 1 week time needed for the final.
Last chance is provided. Last chance is provided to the APDCL to obtain instructions in the matter. Release the matter after 2 weeks. Last chance.
29.
If outstanding amounts for what's done, but
See, as per my instruction, Lordship, the pending liability is Lordship, given, Lordship.
Huh?
Pending liability, Lordship. There's
Ah.
some liability admitted, Lordship.
I have given a copy. Let him see, just let him see first. Otherwise, again, so that he has some clue about what's happening.
if they have stated this much is payable, let them pay lot of regarding the rest of the amount.
Alternative remedy is available also.
But if total claim was lodging and
Okay, right.
53,000, lodging 209.
Heard Mr. M. Bhagavati, learned counsel for the petitioner, as well as Mr. N. Upadhyay,
Lordship.
learned counsel for the
Respondent.
all the respondents. Full stop. The petitioner herein has paid for release of his outstanding bills amounting to
Lordship, page 15. Sorry, Lordship. In a synopsis, the second page, Lordship.
amounting to rupees 19,53,209 for various works undertaken by him under the irrigation department, government of Assam. Assam. Next, Mr. N. Upadhyay, learned counsel for the respondents, has submitted letter number A/72/PT-Roman 3/2023/845 dated 18/8/23 issued by the respondent number issued by the respondent number 5
Lordship.
issued by the respondent number 5. Along with the annexure and the parawise comments in respect of the present case. Pusta. The annexure to the above letter dated. No. Parawise reply, which states that the respondents have admitted, which shows that the respondents have admitted that there is an outstanding liability of rupees 16,27,019 payable to the petitioner. Pusta. Mr. Bhagavati, learned counsel for the petitioner, submits that the admitted amount may be directed to be given to him, and he will take recourse to other alternative remedies for recovery of the other amounts. Next. On here, I have heard the causes for the parties. The letter dated 18/8/2023, which has been issued by the respondent number 5, is made a part of the record and marked as Annexure X. A perusal of the same and its annexure shows that the respondent number 5 has admitted that the petitioner is to be given his outstanding liability of 16,27,019. In view of there being an admission of the amount payable to the petitioner, contractual amount payable to the petitioner, this court is of the view that the writ petition can be disposed of with a direction to the respondents to consider the case of the petition for payment. Accordingly, in terms of the judgment passed by the full bench of this court in Tamsher Ali versus Union of India. Who is the chief engineer?
Lordship,
The respondent number 4 is directed to verify the outstanding liability payable to the petitioner, and on certification of the admitted amount, the admitted amount should be paid by the respondent. The entire exercise should be concluded within a period of
4 months.
4 months from the date of receipt of a certified copy of this order. With respect to the amounts not admitted by the respondents, the petitioner is given the liberty to avail of the other alternative remedies available, if so advised. The writ petition is accordingly disposed of.
Sorry, 41.
What is this?
Matter was listed yesterday, my lord. The relaxation clause was there, my lord. I'm MSME registered entity, my lord. Yesterday it was listed.
Yesterday, my lord, it was listed, my lord.
It was listed yesterday. Acha.
Lordship.
Just a minute. Okay, yes.
My lord, let me submit, my lord. My lord, yesterday it was given an impression that this tender is for some work order or something like that, my lord. Now, my lord, I'm coming to page number 22 of the writ petition, my lord. My lord, page number 22, my lord. This is the, my lord, tender. The tender pertains to, my lord, e-procurement system and these for particularly empanelment, my lord. Nothing more than that.
Notice inviting bids in 2-bid system
Yes.
to for empanelment of
This is for, my lord, empanelment of suppliers. This is not for supplying something, my lord. These handloom accessories by which these shawls are woven, my lord, at village level. Those equipment, my lord. So we are going for to make a panel and listed manufacturers. That is the thing, well, first thing. Now, my lord, coming back to this. Now, what my friend was referring to, page 35, the relaxation part, my lord. 3E. 3E, my lord.
3, yes.
That is what his case, my lord, that there is a relaxation part and
Small scale industry is not required to
yes.
submit that document. Earnest money, I think. Earnest money.
Yes, that was his case, my lord. So, my lord, I'm going to read it again, my lord. As per the government policy circular number such and such of 2016, issued by the Development Commissioner, MSME, Ministry of Micro, Small, Medium Enterprise, Government of India, Micro and Small Enterprise. MSME are exempted from prior turnover and experiences in all public procurement subject to the meeting of quality and technical specification, my lord. There is a, my lord, rider
safety. Means safety means what, my lord? If there is an issue of safety, we can bend. Safety means, my lord, see, my lord, these are that accessories, my lord, a woman will be using this for, my lord, waving clothes. Suppose, my lord, the wooden shuttles, my lord, doesn't work properly, it breaks down, my lord. Their injury may cause. That is why, my lord, that safety part is there. Now, my lord, the bidders needs to submit up-to-date copy of the certificate of registration that he has submitted, my lord. And moreover, next page, my lord, moreover, the bidder must be a genuine manufacturer of handloom. That
No,
clearly.
no, he's on 13P only. 13P.
From here, 13P comes, my lord. 13P,
Page 42.
page 42, my lord.
CE read with 13P. That's all his case is.
Exactly, my lord. So that is what I'm trying to, my lord, make my case out.
Yes.
So, my lord will, this page 36, my lord. Let me just finish once, my lord. Wooden certificate, in case of MSME payment of EMD and bid costs are exempted as per government notification dated 27/10/22, my lord. So, my lord, there is another rider that they will be exempted from giving EMD. No EMD is required. Now I'm coming to, my lord, page number 42, 13P. This is the, my lord, condition of tender, my lord. Work completion certificate for minimum of 50 lakhs only during last 3 financial year for the component competent authorities as a supply. So that was the condition.
Your case is 13B or 13P?
13P, my
P, my lord. This
P.
is the one. So, my lord, we have put this
So
condition, my lord.
P is not connected with CE.
I was disqualified only because of 13.
My lord, there is let me open up, my lord. Now, my lord,
I am just saying what you are going to say. So let's not waste time. 13P
I was disqualified because of 13.
disqualified because of 13P. P for Punjab, correct?
Lordship.
Now 13P has no connection with CE.
Here, my lord, experience clause is there. Experience.
Where? In
13P,
CE.
my lord, work completion certificate for minimum amount of rupees 50 lakhs.
Oh.
13P, my lord, page 48, my lord.
Yeah.
Only during last 3 financial year from the competent authority as experience of supply of loans and association. I could not submit my lord experience certificate, my lord.
So
Therefore, my lord, I, my lord, refer my lord 3E, my lord, where my lord relaxation clause is there, my lord, since I am a my lord MSME registered.
no, but 3 is only for
MSME
as per so
experience
are exempted
prior
from prior turnover and experience in all probability subject to be exempted from prior turnover.
turnover
So
and
this does not talk about turnover.
prior turnover clause is also there, my lord 50 lakhs
Okay.
prior turnover is there, my lord,
So prior turnover.
and experience, my lord.
my lord will just note that my friend has submitted that he could not submit any document, that experience document, my lord.
To meet up, my lord, 13P.
He has just submitted, my
Although I
lord.
have submitted some document, my lord, to meet.
My lord, I'm coming
Okay.
next, my lord. Now page number 57, my lord.
57.
Page number 57, my lord, of the writ petition. This is a pre-bid meeting, my lord. So, my lord, in pre-bid meeting, we have called up everybody. Then, my lord, we'll see clause 2, 13P. The second clause, my lord.
Yes.
Here, my lord, that 50 lakhs thing was discussed and we have brought it down to 10 lakhs. My lord, it is not that we have done it in a harsh way. There was an objection of the 50 lakhs. So that was brought down in a pre-bid meeting, my lord, to 10 lakhs. He remains silent.
I was not there in the.
My lord, he remains silent. Now what happens, my lord? He submits few documents. It is not that he hasn't submitted, my lord. In tender, he has uploaded documents. I am placing it before your lordship. These are the documents.
Yes.
I have just extracted these documents from the my lord, but these did not meet the requirement. My lord will find these are the documents he has uploaded. He has joined the tender. Now, since his document doesn't meet, now he is falling back to this. He should have raised in the first instance, my lord. He did not raise in previous meeting also about this. And now, my lord, first page. This is the work order supply, this Jinko Enterprise of 3 lakhs. And then the rest, my lord,
Where 3 lakh?
this first page, my lord, this Jinko Enterprise, my lord.
Ah, yes.
My lord will find, these are the documents he has uploaded in the, for experience and turnover, my lord. It is not that he hasn't, my lord, submitted. He has submitted only 3 lakhs, and others, my lord, these all falls within private entity. He has given to some Sangha, somebody, my lord. So we have rejected. We say government entity. You have worked at least 10 lakhs. He remained silent throughout, my lord. He thought that this will work out. Because of this, my lord, he got rejected by. Now, my lord, 10 people have qualified. This is for pure empanelment, my lord. So, my lord, my prayer is that now, and I will file an affidavit to that effect, my lord. My lord will issue notice, my lord, and let us continue, my lord. There is nothing.
Correct, there's nothing, there's only a question of impanel. He can be impaneled later on also.
Later on also, my lord. For that, my lord, it should not, others should not suffer, my lord.
Heard Mr. K. Barwala for the petition. And Mr. Ardhar for all the respondents.
All the respondents. No, my lord, they are private, I cannot, my lord. Only
For,
government.
and Ardhar for the respondent numbers,
My lord, 1, 2,
1 and 2,
1 and 2.
1 and 2.
My lord, these are rest are all private.
Right.
Notice to them.
Issue notice to the respondents number 3 to 12. Petitioner takes steps for service of notice upon the respondents number 3 to 12 by registered post secretary within a week. List the matter after 4 weeks.
My lord, there is
To-
interim there.
To enable the respondents to file their affidavit. The interim order passed earlier is stands vacated.
My lord,
My lord,
deeply obliged.
the employment, this matter shall not be published, finalized, my lord. Without my lord, documentation of this, otherwise, my lord, I will accept affected, my lord.
No, my lord, now there is a long process. Now
There is exemption, my lord.
we will visit, my lord, every,
I was already disqualified in the financial technical bid.
Huh?
I was already disqualified in the technical bid, my lord. And my lord, if my lord finally
I'll
be my lord,
Huh?
I will be out, my lord. If my lord finally appointment list is published.
my lord, this will be.
The empanelment of the petitioner will be subject to the outcome of the writ petition.
My lord, deeply obliged.
Appreciate it.
Lordship, matter will be taken after some time, your lordship. She is on legs at court number 20, your lordship.
What is this? That Mandir committee?
Yes, my lord.
What is the period of a Mandir
My lord,
committee?
period is mentioned my lord, in the constitution as a 3 years, at page, my lord, 18, my lord. And
Page
they
18.
have already, my lord, continued for 11 years. And no, my lord, AGM, and no, my lord, books of account.
Page
Page
18.
18, my lord. Executive body 13, and the last part at E, my lord, the term of the office of the executive body and its member shall be 3 years, my lord.
Okay. After some time.
Sometime.
Yes.
32. Hello. Matters has come up today for appointment of
Arbitrator.
arbitrator, my lord. And my friend was here, Mr. Ahmed,
Yeah.
and I'm sorry, led by Mr. Sharma. So notification number 99, my lord,
Where is
dated 4th of August, that was proposing the name of 2 judges of this court, my lord, retired judges.
No, it's like this. You have to propose your own name. And then if they're supposed to be 3 arbitrators or 2 arbitrators?
Single, my lord.
Single or single?
My lord, before we come to this, my lord, I have some preliminary technical objections here. My lord, if your lordship comes to the last page of the petition, arbitration petition, that is a page 60, if I may read it. Heard learned counsel for the petitioner has submitted that the petitioner may be allowed to withdraw the writ petition with the liberty to file afresh.
Page 16.
Page 60, last page.
No pagination. Anyway. Page 60.
60. It's the last page.
Yes.
To withdraw the writ petition with the liberty to file afresh. In view of the above submission made by Mr. Chaudhary Learned Counsel for the petitioner, the instant petition is dismissed on withdrawal with the liberty as prayed for. Now, again, if your lordship comes to the previous annexure 9 at page 57, this is the notice that is required under section 21 of the Arbitration Act.
Page?
Page
57.
57, annexure 9.
Yes.
So this is the notice, the mandatory notice for initiation of arbitration proceedings. In the next page, at 58,
This is by whom? By the petitioner?
by the petition.
Hmm.
This is a purported notice to us under section 21. Alternatively, that is the second page.
No, it's invoking clause 25.
It is invoking clause 25 of the partnership.
Of the
Deed.
partnership.
But this notice is actually,
terms of
I'll come to
section
that. There's a section 21 of the Arbitration Act. Now, alternatively, kindly make appearance before the Guwahati High Court in arbitration petition number 25 of 2023 for appointment of arbitrator in terms of invocation of section 8 and subsequent orders in order in terms of section 11 of the Arbitration and Conciliation Act 1996. Now, my lord, this is a petition under section 8, my lord. How does section 8 come into play for appointment of arbitrator?
Mere mention of a wrong provision of law
No, my lord,
does not vitiate when
My
there
lord,
does not be.
section
So by mistake, he has mentioned the wrong provision.
Section 8 doesn't apply here. It applies before the civil court, my lord. But anyways, my lord, now before invoking section 11, before coming to this court, notice under section 21 is mandatory. That is, if I may read it, my lord,
Yes,
the
yes.
Arbitration and Conciliation Act. What does section 21 say, my lord? Commencement of arbitral proceedings. Unless otherwise agreed by the parties, the arbitral proceeding in respect of a particular.
Okay, now we have, okay, that he has not done. 21 he has not done, according to you.
My lord, they have to issue us a fresh notice.
That has been done.
Huh?
That has been done. My lordship would turn to page 53. 53 at annexure 8.
Ah.
To the respondent, we have issued a invoking clause 2 and 17 of partnership deed for return of so much exit by a client in terms of clause so and so. Then, my lord, we come down. It goes into depth, my lord, and then failure to respond on page 56. Failure to respond from 15 days of receipt from the legal notice will constrain a client to take appropriate legal action which may include both civil and criminal proceedings statutorily permissible as rights vested on our client. Now, the other case, the other notice, my lord, was pointed out by
No,
my
you
lord.
see, what notice he's talking about
My lord, it's
is
21.
that notice to appoint an arbitrator, that has to be made.
They had made a notice to appoint an arbitrator. We disagreed with that and came before this court.
My lord, may allow them to.
They wanted to appoint an arbitrator.
They wanted to appoint an arbitrator.
We disagreed because that was an unknown
But
person.
now you want an arbitrator.
No, we
And-
want a list from the list of this court, my lord. They wanted an arbitrator of their own choice, which we disagreed with.
So that, you see, now that has gone. That period has gone now. So this is for a speedy mechanism to resolve your disputes.
We
That issue, I agree that he should have done that because limitation will start from the date the notice is issued.
173 of the Limitation Act.
137.
Oh, sorry, 137 of the.
So, correct, he should have done that. He's not done it. But at the end of the day, now it's here. The only thing is now whether there is an arbitration clause and whether the matter prima facie is arbitrable. That's all.
Arbitration clause is there, my lord.
Let us see the arbitration clause.
My lordship would find that at page,
It's clause 20.
page 29, my lord, clause 25. Page 29, if my lordship has got the pagination. And at the bottom, clause 25. Single arbitrator, credits or effects to the partnership account, business or transaction whatsoever arising between the parties hereto, or the legal representative, whether raised during continuance of a single arbitrator, the parties agree upon one.
This, this clause is really haphazard.
My lord, done in by my colleagues in Bangalore, my lord. They may be having a different standard of drafting.
Board of
compared to-
arbitrators and all.
The whole clause is very confusing as to what-
Very, very confusing.
Very confusing.
Only thing is that word arbitrator is there,
My lord.
dispute is luckily there. So anyway, the implication is that any dispute.
Conducted in the
So
manner
and the
provided in the.
arbitrator and the decision of the, so the venue will be here.
My lord.
Because the cause of action has arisen here.
Everything here, my lord.
Seat and venue not mentioned,
No, my lord.
but because of the cause of action being here and you have come to this.
by
court the first-
implication.
Ah.
the benefits.
So, okay. So then we appoint an arbitrator?
My lord.
Any objection?
My friend, my lord, prefers any arbitrator.
Would my learned friend agree to Mr. Mahmood Ahmed?
No, my lord. From the list in conference 99, since the amount is large, we perhaps Justice C.R. Sharma, my lord.
I don't know if you all can decide. this.
Justice C.R. Sharma, because the amount is above the limit for Mr. Mahmood. It was the wrong thing here.
Look, as
You
per
got the wrong
Eastman Perkins, none of you can appoint an arbitrator.
You got the wrong
Yep,
notification.
If they are, they might be hit by that
Provided by the court.
section 12(5), no? And the
Mr.
schedule
Mahmood is
7.
not there.
So I don't know, otherwise, if you all don't agree, I'm going to appoint. So I want you all
Justice
to.
C.R. Sharma is our proposal as per the notification 99 dated Guwahati for High Court.
Yeah,
4th of
Sharma.
August.
Okay, right. All right. Heard Mr. P.N. Chaudhary, learned counsel for the petitioner, and Mr. P.P.
So R. Sharma.
Mr. R. Sharma, learned counsel for the respondent number 1 and 2. Who will appear for 3? No one.
No one.
No one appears for the respondent number 3.
One is the enterprise.
Okay, huh?
One is the enterprise.
My lordship, actually, 3 has been listed by me as a party with my lordship because of the view that perhaps.
He's not a
listed
party,
because
he
he's not-
he
he's not a
cannot be,
signatory to
he
the-
cannot invoke.
He's not a signatory.
Only
to
it is
the-
1 and 2.
Only one. You see, if he wants in his individual capacity to come into the
Lord,
proceedings,
sorry.
he can apply under this section 16 is there.
Yes, my lord.
The arbitrator can decide on his own
It's
jurisdiction.
no way connected with this.
No, that we have said, we have raised the.
Okay, right.
reasoning.
So you are appearing for whom, Mr. Sharma?
For 2 and 1, my lord.
Because what has happened is that there has been a plethora of mistakes here. Now the petitioner sends the notice himself in the name of respondent number 1, and he himself has made he is a petitioner who is the owner of Upasana Enterprise,
Raise all
and he's
those-
sending a notice to Upasana Enterprise, who is in the respondent number 1.
You can raise.
Why
all
he is
these-
sending his notice to himself?
Yeah. Because we were the managing party.
Anyway, leaving that aside, you are appearing for whom?
2 and 3.
2 and 3.
Only two. Only two.
Appear for respondent number 2.
Two and one.
Good stuff.
You're not appearing for Upasana Enterprise? Only half of it.
You're a partnership. You're having a problem.
Partnership has been invoked that we dissolved. the
Oh, so 2 and you are enough. Right. The petitioner has paid for appointment of an arbitrator
2 and 3 are partners.
in terms of section 11(6) of the Arbitration and Conciliation Act, hereinafter referred to as the 1996 Act.
Amended as in 2015, madam. If I may so.
Amended in the year 2015, as amended in the year 2015. Full stop. So you take this, I think this page, no, order dated 6/2/2024. Just take this paragraph, this one, this in red. in this one,
When we exported, supplied this to us last time, I think your junior is not giving it to you. 2 dates, this is before you took an adjournment on that date.
then next para,
I think there was some other term.
Mr. R. Sharma, learned counsel for the respondent number 2 submits that he does not have any objection to the prayer made by the petitions counsel. System. Next para, Mr. P. H. Chaudhary, learned counsel for the petition, Mr. R. Sharma have both agreed that that this court may appoint Mr. Honorable Justice, Honorable Mr. Justice C.R. Sharma as an arbitrator to decide the dispute between the parties, in as much as he is in the panel of arbitrators made by the Guwahati High Court by notification number 99 dated 4/8/2020. Next para. Next para. Next para. On considering the fact that the respondent number 3 is not a partner, is not a party to the partnership deed,
Not a signatory.
naturally, in a party. This court is of the view that there be no binding agreement between the respondent number 3 with the petitioner. With the petitioner, the respondent number 3 should be struck off as a party from this case. Accordingly, the respondent number 3 struck off as a party from this case. Next para, in view of the consent of the parties, Honorable Mr. Justice C.R. Sharma is appointed as arbitrator to decide the dispute between the parties. The party shall approach the learned arbitrator within a period of
4 weeks. 4 weeks. 6
within
weeks.
a period of
6 weeks.
within a period of 6 weeks.
It's from Bangalore. And she's in the advanced case. So
And take steps with regard to whether and take steps to justify to ensure that to certify whether the said arbitrator does not have any not the objection. The 12.5, I think, 12.5 in the schedule. Arbitration Act.
Under the amendment.
Whether this is the old one, where is the new one?
Anyway,
Arbitration Act, new one.
when did, have you got the new?
It's 2010, very old.
we got 2018 publication.
And I've got now. I think keep that away, yes. So that he does not, to certify that he does not have any disqualification in terms of section 25. Section 12, bracket 5 of the 1996 Act and the 7th schedule of the said Act. The arbitration petitions accordingly disposed of.
Deeply obliged, man. Obliged, man.
Fees, everything you have to do it yourself within,
Miller.
or as per the schedule.
Obliged.
There is a yellow order of this.
Yes, Mr.
The problem is loss of fund loss. In fact, we have written the finance department also lost.
No, no, I'm not talking about fund. I was saying, is it admitted? It's admitted.
It is admitted loss, admitted amount loss. You can, in fact, loss, we return to the finance department to provide some fund loss.
What to do?
Otherwise, my lord, the bill pending since 2014, my lord. And
We have communicated for loss of giving us some contingency fund also lost. It is not coming.
But what to do?
Finance is not a party here.
Finance not a party. You bleed the finance.
the party, my lord. Respondent number 3, my lord.
Oh, finance party has said.
The problem is we all have got so many unpaid bills.
In fact,
But,
loss
we keep hearing in the, we sometimes get the impression that money is there with the government.
The petitioner install the air condition machine, my lord.
Huh?
Air condition machine, my lord.
Ah.
The secretary office, my lord.
Okay, okay.
In the year 2014, my lord.
Oh, installed air condition.
Air condition.
So now they're not
Machine,
paying.
But now saying that the fund is not available.
You should have installed a second hand
My lord.
broken down. Anyway, what to do?
That is the respondent number 3.
Okay, right. Mr. N. Upadhyay has submitted letter number CEI bracket A bracket C 05/2020/23 dated 4/3/2024 issued by the Chief Engineer, Irrigation, which is to the effect that the department would be making payment to the petitioner as soon as fund is received from the State Finance Department. Yes, Mr. Gogoi.
I would like to have a question. Grant me at least, but he's showing a letter of mine of 22 to 24.
No, 4/3/24.
Yes. Yes.
4th March.
I can have that. Only one which type.
Mr. B. Gogoi, Learned Counsel for the Finance Department, submits that he will obtain instructions with regard to the above. This is the matter after a week.
Online. 34.
May I please, I am appearing for respondent number 2, 3, 4, and 5. Which is tomorrow I will file affidavit.
Okay, right. Mr.
D. Sutia.
D. Shuti appearing for
2, 3, 4, and 5.
4 and 5. Submits that he will be filing affidavit tomorrow. This is the matter after a week.
But the date may be fixed. Date may be fixed.
Give a date.
19.
In the meantime, no, the respondent may thereafter file, the petitioner may thereafter file affidavit in reply. Comma if required. Item
30, lordship. 30, May it please the lordship.
yes.
In
What is to be done here?
Lordship, in this case, the petitioner is a registered society, Lordship. There are Radha Govinda Sevashram, Lordship, conducting the activities of a temple, Lordship. When their society is in existence, Lordship, the executive magistrate dissolved the committee,
Dissolve what committee?
that registered society, Lordship.
Did
They are-
he dissolve the society or dissolve the committee?
Dissolve the society, Lordship, that.
Where?
Imperial order is page 30, Lordship. In fact, the committee has to be
Let us see
dissolved
page
by
30.
page 30, Lordship, annexure 7.
No, it dissolve the present Mandir committee. It's not
Yes, Lordship.
society.
That is the registered
No,
society.
the question is, I'm not on whether he has got the power or not. According to you,
In fact,
he doesn't have the power.
yes,
The question is, what is the term of a Mandir committee?
Lordship, until and unless it is dissolved by 2/3 member of the committee, Lordship. There has to be a general meeting, there has to be,
Is there a term?
No, Lordship.
There's no term.
No, Lordship. The bylaws I have annexed along with this.
Page 18.
Lordship will find the bylaws I have annexed along with this writ petition annexure 3 page.
Where do you, in the bylaws, where does it talk about committee?
Lordship. Dissolution of the society, Lordship.
No, no, not society. Dissolution of the committee. We are not on the society. Society is different.
It is a registered society, Lordship.
It is a registered society, but
Yes, Lordship.
you see, there are many societies in Assam.
Lordship.
And the societies are run
Or-
by the managing committee usually.
Lordship.
So out here also the society is there.
Lordship.
Now, what is the society name?
Lordship, Sri Sri Radha Govinda Sevastram.
Now that society is being run by a committee.
Lordship.
Now, where is the definition of committee? Is it there?
Lordship. For that, I have to see, Lordship. that
Okay. Now,
President, duties of the office bearers, president, vice president, secretary, page 20, Lordship.
page
20, Lordship.
20.
Quorum of the AGM also is there, Lordship.
So
as
duty of office bearers. Office bearers of what?
Lordship.
Executive body.
President shall be an elected office bearer. President shall preside over all the meeting of the executive body and general meetings. President shall guide, advise the secretary in a manner requiring in Lordship urgent,
So my question is number one.
Lordship.
Is there any, you see, because your letter talks about Mandir committee.
Lordship.
In your bylaws, is there a Mandir committee?
Lordship, my case is that we are a registered society,
Yes,
registered under the society's registration. Act.
correct,
So
correct.
it has to be dissolved by the registration.
Madam, I understand that,
Lordship.
but in your page 30,
Lordship,
show me where there has been a direction to dissolve the society.
in my bylaws, Lordship.
In your page 30. In that page 30.
They have said,
It's-
Lordship, Mandir committee.
So is Mandir
Mandir
committee and
committee-
society same?
Yes, Lordship,
So according to you, Mandir, the society.
the
Okay, I've read
society, Lordship, the society is governed by the governing body and the executive committee, Lordship. That I have written, the president society
Okay,
functioning.
okay, madam, okay, I think I've heard enough. Now please
Executive body of-
come to page 18.
Lordship,
Come to page 18. I think we're beating around the bush too much. Come to page 18, come to the president, page 5,
Lordship,
13(1)(e).
executive body,
The
Lordship,
term of the executive body and its members.
Lordship.
Please look at this.
There shall be the following office bearers in the executive body. President, vice president, secretary, joint secretary, assistant secretary, treasurer, organizing secretary, office, Lordship. Normally on completion of 3 years, Lordship.
When you say normally, it says, please do not insult my intelligence.
Lordship,
It does not say normally, it says the term of the office bearers of the executive
Shall-
body and its
shall be
members shall be 3
3
years.
years,
That's all.
Lordship. But for that, Lordship.
However, it may be dissolved now. How long have you been an executive body?
Lordship, it was. Since my lord inception, they are holding the post for last 11.
So then
Lordship.
we'll dissolve it.
Lordship, we are inviting the membership from the.
No, madam, I'm only reading your bylaws,
Lordship, that is our bylaw.
your bylaws.
Lordship,
Now, this bylaw differentiates between the society and the executive body.
Lordship,
Now, the document that you're talking about, that page 30,
Lordship,
talks of Mandir committee.
Lordship,
Now, according to you, Mandir committee and society is same, which is absolutely wrong.
Lordship.
Now, is Mandir committee and executive body the same?
No, Lordship,
If it is not the same, then how does that ADC letter or ADC direction have any bearing to your, have any connection to your case? It is of no use. There are three ways of looking at it. Either way,
Lordship.
but at the end of the day, if you carry on with this petition, we have to dissolve, we have to ask for a new election as per this.
Lordship, for that we are agree, Lordship.
Then-
For that, for new
We are
election,
also-
we are agreeable.
Then the
We
end
are
of the matter,
Lordship.
then the end of the matter.
Lordship, but Lordship, they have occupied the entire mandir and
No,
everything.
no,
was
now
under
you
them.
have so the mandir, whoever is going to control or be the new office bearer, they will now look after that issue.
Lordship, how they have entered and how they have Lordship.
Madam, I do not
I
know,
have
that,
already
that
filed
issue cannot
FIR
be,
also, Lordship.
that issue cannot be decided. The issue is when the executive body is to be there for 3 years only,
Lordship.
and if it has been there for more than 3 years, then how are they to be selected by election?
Yes, my
Yes,
lord,
Lordship,
but
but
through
how
AGM,
they
my
have
lord.
elected.
By
Lordship.
EGM,
Annual
then
general
we will
meeting.
tell them to have a EGM. Where is that page?
Whether they have Lordship any election, there is any election, how they have constituted, how they have entered the mandir Lordship. Now later. on,
Madam, supposing we say, okay, their election, the post that they're holding now is illegal.
Lordship,
But for the new persons to come in, they have to hold.
no, for that election has to be.
Have to have.
Lordship.
So we are going to say whether they are rightly or wrongly gone into it, that is not an issue now. The issue is who is to be the executive body.
Lordship.
That's all.
For that Lordship, at least there should be some procedure. They have to take Lordship, the handing over charge from the earlier committee.
So who will
Lordship.
decide that? What does your bylaw say?
Lordship. There should be a meeting, Lordship, and after that.
Correct.
Lordship.
So it should be done as per this. You see, notice for the executive body meeting, the secretary in the absence says so, the joint secretary says so,
Lordship,
so
that
and so, so. Everything is here. It is provided.
Duties
in
of
your-
membership also there,
Huh?
Lordship.
Huh?
Duties of members are also there, Lordship.
Everything.
So they are not the member. When we were the member, Lordship, our committee was.
Madam,
also-
if that is the case, those are disputed questions of fact, you go to civil court.
And Lordship, when the notice was issued, Lordship, that impugn order was stayed, Lordship. And during the pendency of the writ petition, how they entered into the mandir, Lordship, and their.
See, those
disposal
issues,
of-
you see, those issues, they are going into the small nitty-gritty.
Lordship.
That is not going to decide the issue. At the end of the day, what is going to decide, who is going to control the temple
Lordship.
is the one who is the executive body. Now, executive body has to be decided.
Lordship.
Whoever is holding that post is now, it is not as per law because the term is finished.
Lordship. But
So-
Lordship, Lordship, their committee is also illegal as they have no authority to.
So who will decide? Who will be the authority to conduct the election?
But
You give me an.
Society
18, my lord.
Registration Act is there, Lordship. Society also can be complained, Lordship. They can also take initiative and the society.
Okay, we can,
It
if you both agree
Lordship.
and you want a fair election, we can tell the society to do it.
Yes,
The
Lordship.
society office bearer.
At page
Lordship,
18, my lord,
our
this is provided, my lord, at page 18, my lord. There shall always be office bearer of president, secretary, treasurer in the executive body. The rest post, if required, may be kept vacant for the time being. My lord, C, the office bearers and members of the executive body shall be elected by the primary members of the annual general meeting.
No, Mr., it's not that. The issue is who are the members, who are not the members, that will be decided by the registrar of cooperative society.
Lordship. He has filed affidavit, Lordship, in this case.
So let him, who is for the cooperative society? The registrar? Who is appearing? Yes, what is to be done?
Take up the executive magistrate affidavit, Lordship. Prior to issuance of that order, Lordship, there was some inquiry. So,
Mr.
they
Council,
were-
do you know what we're talking about?
Yes, yes, yes.
The term of the executive body has expired. So what is required now is a new body has to come up as per the bylaws. What has happened, whether they are whether their membership is as per law or not, we do not know. We're not going into that. That cannot be decided by us. That has to be decided by civil court or by the registrar. So now the only thing is that we want a fair election to be held. Now, who will conduct that fair election?
Then register of the society.
It's register of the society, my lord. They will, my lord, agree with it.
They will let them decide
Sure.
who is the member who can vote. है ना? So the dispute is between you and the respondent number
Private respondent, lordship.
6-2?
Lordship, 6 to 18. Lordship, prior to a implement of the private respondent, we have filed this writ petition against the respondents, lordship, official respondents. After that, the Registrar of Societies Act filed affidavit in opposition. Then, lordship, when they entirely entered into the mandir, lordship, they are occupied all the documents of the present society, lordship, the Radha Ashram, that is the Radha Govinda Sevashram, lordship. So we filed an interlocutory application praying before this court just to refrain the private parties from doing any illegal activities within the committee of the Mandir Lordship. That interlocutory application was rejected by this court only on the basis that it is a final relief that has to be decided at the Lordship adjudication of the writ petition only. So that after dismissal of that interlocutory application, we have filed one IA for impleadment of the private respondent.
So they have been implemented.
Yes, they have been implemented and only yesterday they have filed their affidavit in opposition.
So
So only I am praying to file reply to the.
why
affidavit in
why
opposition
should there be a
because the-
reply?
As your lordship is taking up this matter, your lordship can dispose it up finally. I have no objection. As because the registrar's affidavit in opposition is also in the records, it says that our society was validity has been extended up to 24/7/2024.
It is my lord. That is, my lord, society. The validity of the society.
Society.
Registration certificate.
But earlier we are the lordship committee, then who are they lordship? How they entered into the activities of the mandir lordship?
That is it. You see, the issue of whether who is a bona fide member, who is not a bona fide member,
Lordship.
that
For
this
that
court
lordship,
cannot
an
decide.
election has to be lordship there.
Election has
Without
to
any
be held.
election,
But who will make the voter list?
lordship.
Who will make the voter list?
Now lordship, we have been ousted from the mandir committee.
So who will make the voter list according to, by the registrar or what? Or his representative? Can this issue, this case, why has it come before this court? Why doesn't it go before the registrar?
For that only, we have filed this writ petition that the executive magistrate has no authority to dissolve the.
No, madam, that is all right. Your prayer is all right, but we are going beyond that.
Lord.
We are going to the issue of whether they should be, whether the executive body can carry on when his term is has been ended. He cannot carry on. So there's no reason to interfere with the order of the executive magistrate. Though supposing he has no power, still it doesn't take away the fact that new executive body has to be there. Right. Heard Miss R. Chaudhary, learned counsel for the petition. Mr.
SR Murwa
S.R. Barwa appears for
from the respondent number 1 to 5.
respondent number 1 to 5. While Mr. S. Sarkar appears for respondent numbers 6 to 18. And this order dated 20/10/22. Para 4 and 5. So, as far as the petitioners counsel submits that you are the executive body, who are you? No,
Lordship, governing body, Lordship.
you are the governing body.
Yes, Lordship, true. The
Submits that
petitioner
the
society functions through its executive body, governing body, Lordship.
submits that the petitioner society is governed through its governing / executive body. In terms of the memorandum of association constitution of Sri Sri Radha Govinda Sheveshram. She submits that the private respondents have, in the meantime, surreptitiously entered into the premises of the temple and taken control of all the documents. Correct? Control of all the documents.
Yes. Lordship. Yes.
She submits that as the executive magistrate Bogaigaon does not have the power to dissolve the executive body, governing body / executive body of the temple. The meeting minutes. The meeting minutes has to be the meeting, wait, page 30, the meeting.
Mandir committee with immediate effect and form.
No, just a minute. The meeting minutes dated 19/9/22 issued by the executive magistrate Bogaigaon should be satisfied. Next. What is your case otherwise?
Since inception minus in the year 2013, he is running the society without giving any books of account or holding any general meeting or even executive body. And therefore, the public has ousted them, my lord, and public by meeting, my lord, on 29/2000, my lord, 2022, my lord, has chosen us to, my lord, brown the.
Okay. The Mr.
May I point out one thing, Lordship? Annexure 6, page 26 is our reply. We have, Lordship, forwarded every document to the additional.
Anyway, I'm not on that, right?
Lord.
Mr.
Yes, sir.
L. Sarkar, learned counsel for the private respondents, on the other hand, submit that the petitioner has been looking after the mandir through the governing body / executive body since 2013, without holding any AGM and
Giving any books of account to the.
furnishing any books of accounts to the members of the temple, to the members associated with the temple. He submits that in view of the above, the people, the general public had taken over the temple and made the private respondents run the temple. Next, Mr.
S.R. Purwal,
S.R. Barwa, the learned counsel for the
Executive Magistrate Lordship.
respondent number
5.
5, submits
Lordship, the order to the 19/9/2022 passed by the Executive Magistrate. He had taken into account the 3 reports submitted by the Assistant Commissioner. That report dated 1/7/2022.
no, regarding what?
On the basis of that, some public complaint was there.
What did the report say?
A report says that they could not provide the documents, the relevant documents of their
Or management of the temple?
management of the committee. And there was decision to convene a public meeting but they did not follow it.
Submits that there was no infirmity with the decision of the executive magistrate to dissolve the governing body slash executive body of the temple, inasmuch as the same had been made on the basis of 3 reports made by a government servant. So stop. In the reports, it was seen that the petitioner had not been able to give proper accounts of the management of the temple. So stop.
That was not mentioned in the.
Anyway, that is his submission. He can submit
Affidavit
anything.
about
He can
procedural
say,
matters.
he can say President Trump is a Chinese also. How does it matter?
The affidavit
That
in
is his
opposition
submission.
Silent about this.
Anyway,
Lordship,
I have heard the
it is
learned
written in
counsel for the party.
report.
So stop. Without going into the various issues raised by the counsel for the parties, comma, it is noticed that in terms of clause, in terms of clause 13 bracket E of the Memorandum of Association Constitution of the Sri Radha Govinda Shiva Shram, hereinafter referred to as the MOA, Constitution, referred to as the Constitution, the term of office of the executive body and its members is 3 years. However, it can be dissolved / terminated early only under special circumstances. First up, clause 13 bracket E of the Constitution is reproduced herein below as follows. Page 18 in red, okay? First up. The next para, the concerned temple has been established when?
In the year 1960.
In the year 1963. So till then, and since then, there has been no AGM.
No, since 2013, but 2013 was.
Okay,
There
so
was
they
no-
have been there from 2013.
Okay.
Okay. Submit that what have I said? Has been established in 1963. Good stuff. However, the petitioner has been looking after the temple through the governing body / executive body since 2013 without there being any further election for the various posts under the executive body, in violation of clause 13 bracket E of the Constitution. Good stuff. In that view of the matter, the validity of the executive body of the temple having expired, they cannot be considered to be the executive body members any longer in violation of clause 13E of the Constitution. So as such, this court is of the view that a fresh that is of the view that where is the election? How is it to be done? Is of the view that
In the bylaws, Lordship.
is of the view that
Membership, clause 7, Lordship, and clause 8, expulsion, removal, creation of membership, clause 9.
no, not new member. I'm talking about new executive body.
Executive.
And is of the view that the office bearers, a new set of office bearers and members of the executive body shall have to be constituted in terms of clause 13 bracket C of the Constitution, wherein it provides as follows. Page 18 itself, okay, in red. However, in view of the fact that, in view of the peculiar facts and circumstances of the case, this court is of the view that the AGM, the election of the new office bearers and members of the executive body shall be held under the AGIS of the registrar of societies. So stop. Accordingly, who shall call for the AGM?
Lordship, he can appoint the register of societies can appoint administrator to see the.
As per where is the administrator?
That Lordship, the Societies Registration Act itself says that administrator can be appointed.
Accordingly, the as per what provision?
As per section 13, provision for dissolution of societies and adjustment of their affairs, Lordship. That is. The Lordship can direct the registrar to look into the affairs of the society, Lordship.
What? The registrar will do it. Accordingly, the registrar, the registrar shall also manage the affairs of the temple through his representatives till a new executive body is formed in terms of the constitution. Full stop. The AGM for election of the executive body of the temple shall be called within a period of 1 month from the date of receipt of a certified copy of the result. And the entire exercise for conducting an election and declaration of the results should be made within a further period of 2 months. The writ petition is accordingly disproved.
Till then, registrar will, Lordship.
Naturally, I said he will do.
Lordship.
So that's the only way out. I think otherwise there will be no end.
Apply, sir.
Item 43. What is this?
In this case, on behalf of the contenders from the Health and Family Welfare Department, this matter relates to Lordship non-payment of the interest amount of some supply orders. And the main payment was paid sometime in 2005, 2006. The interest amount component was not paid. So now.
Item 43.
43.
Ah.
So now there's a direction of this honorable court to make the payment within 4 months in 2000. If Lordship is pleased to look at page 31, the operative portion is at page 10. Because of the above factors, it is clear that have Lordship got it.
Yes.
Because of the above factors, it is clear that respondents are duty bound under the 1993 Act and also the award given by the Industry Facilitation Council to disperse the interest component to the petitioner for the delayed payment, and consequently, direction is hereby issued to the respondents to disperse the interest dues of the petitioners for the medicine supplied between 1991 to 1999.
the process for ensuring payment should be completed expeditiously and preferably within 4 months of receipt of this order with a direction the case stands allowed and without any cost. So the original amount was very meager, about 16 lakhs 19,156, and that amount was paid in 2004-5. Now, Lordship, they are not very serious because that's why they have not taken steps of the contempt also. But we are serious because on review, we found these are outstanding dues and the interest are accruing in a very high rate, in a componential rate, Lordship. So I have all the checks, whatever is due, we have calculated. For Praxutis, 1,48,85,761. And also the 10% TDS, 16,53,974. It is ready with me, Lordship. I thought that they will be present. There are two cases, Lordship will please to see these two. Second and fourth, the first one, we are paying today about 42 crores in another court. All of those periods of the 90s. And on review, the government has found out all this. And we are also registering a case against those officials who are involved in delaying this. For the 63 lakhs rupees, we are paying Lordship 17 plus 42, 58 crores today.
My God.
And here also, Lordship will see we paid the principal amount in 2005.
For how much? For how much? For?
This is for
16
16 lakhs.
For 16 lakhs, you are paying this.
Yes, the 16 lakhs, we paid the principal amount at that point of time, 5-6. But the interest part was not paid at that point of time. And there is always some nexus of the suppliers as well as some officials. They always want to keep the issue pending. In the meantime, the money grows. So we have already 3 days ago, we have the CM has directed for registration of case by the CM Vigilance Cell in these 2 cases. But we are ready with the check. We want to deposit lots. That there should not be any further accrual of interest.
But why is it this case after so many things?
We mentioned it, Lordship. We mentioned it because now the case has come for not taking of steps. They have not taken steps. Also.
No, it was listed. The last time the petitioner appeared was in August 17.
Yes.
After that,
They
it
are
has been
not
listed
pursuing
only
because they also know and our
Interest.
officials also know.
it is.
Interest, the game of interest.
Okay, right. No one appears for the petitioner on call.
And steps also are not taken.
It is noticed that the last time the petitioner was represented was on 14/8/2017. Besides the above, it is also seen that the petitioner has not taken any fresh steps for service of notice on the respondent number 1. Despite the Lavazima court order dated 10/9/2018. Next paragraph. This contempt petition has arisen out of the order due to non-compliance with the order dated 2/11/2015 passed in WPC 1034 of 2018. Wherein a direction had been issued to the state respondent, the state government, to disburse the interest component to the petitioner in terms of the interest on delay payments. Inverted commas, interest on delay payments to small scale and ancillary industrial undertakings Act, 1993. On the principal amount of rupees 16,19,156. Next paragraph. The counsel for the respondent submits. Okay, have I said Mr. D. Saikia? Earlier, no one appears. Mr. D. Saikia, Leonard Senior Counsel appears for the respondent. Then at the bottom, assisted by Mr. B. Roy. And at the bottom, you write, Mr. D. Saikia, the Learned Senior Counsel submits that the principal amount of 16,19,156 had been paid in the year 2000.
It was paid 2004-5.
2004/2005. However, the interest has not been paid till date in view of the state respondents overlooking the fact that interest was to be paid. So he submits. He has also brought
Graduates.
which one is it?
Second and fourth.
He has also brought the Prague Jyotish. Prague Jyotish is this one. No. Prague Jyotish, correct. Prague Jyotish is this one. Prague Jyotish is this one. What is this yourself?
That is for the income tax part, Lordship. 10% we have deducted,
Okay.
and it has to be deposited in his
He has
account.
also brought
That is 10%.
Union Bank of India check numbers 285642 and 285644 dated 4/3/2024 amounting to rupees 1,48,85,761 and 4,12,41,928. Respectively.
No, that will be different, Lordship. It will be lesser. There are two checks. That is for the other TDS.
Okay.
So smaller amount will be there, Lordship. That 42 crores, 10% is for 4 crores. It will be now, in the other case, it will be around 16 lakhs, I think.
Okay, then there will be like this. One is the 285642, huh? No, that check number is there already. And 285641. Okay. And that 285641, that instead of 412, you write 16,53,974
Lordship.
respectively. Okay. Next para. The senior counsel submits that the above checks are the interest payable to the petitioner. Pustav. Next para. The learned senior counsel for the respondent submits that there appears to be a nexus between the petitioner and certain officials for
Also, if you please to have a look of this note.
delaying payment of the interest as the interest payable under the act is very high. Okay, next. Uh, Now, what is to be done? We'll give one chance.
These two checks we can deposit in a registry, Lordship, whenever they want. And Lordship would be pleased to close that they should not claim any further because there is a default on their part now also. From 2017, they are not pursuing that observation, Lord.
No, I've already mentioned.
And that is, but final, that is Lordship was recording.
I know, I wasn't planning to dispose of straight away.
Straight away, Lordship, it will be better and we'll deposit today itself in the registry. Lordship will direct us to deposit within 1 day.
Okay.
Any formalities to be done. So whenever they will come, they can collect it from the registry by proper identification.
Because they've kept silent for 7 years.
Absolutely, Lordship. And that is deliberate. Our officers also, they never say that we have to pay. I have seen the records, every year there's a sanction. And they deliberately drop it from the final FOC.
Okay.
And we have all the notes. So now the police will be after them, whoever is at fault, our side. Use money, no, it's a small peanut money.
No, they've not come to the court also.
Yes.
I was actually thinking I'll give them one more date and maybe close the matter. But then,
Lordship, maybe please to close it, Lordship.
close it now. With
Yes,
the direction to patients, you have brought the check.
Yes, we'll deposit in the registry.
To stop next. In view of the Leonard Senior Council producing the checks for payment of interest, which is calculated till today, calculated till which year? It is calculated.
That calculation, Lordship, I do not have a specific instruction. Yes, 10/2/2024.
Calculated till.
Submit a phrase calendar, yes. Most probably it is to the date of the judgment, maybe.
Okay, just whatever I said. No, don't say that. Which is calculated, you cut that. This court is of the view that the contempt petition can be closed. First up, accordingly, the Learned Senior Council shall deposit the above two checks in the registry of this court for disbursement to the petitioner as and when an application for the same is made before this court. After getting permission from this court for disbursement of the same.
Lordship, one observation I did, this is closed for finally, Lordship, that
No, this, how can I say this person, they can still agitate the amount before some other, not in this content.
not in this content. That's because some default is on their part also. Because we have the first sanction in 2016 from the
So
record.
the question whether the question, so that is better said, better left.
One line that there's a default on their part, that observations. Today also they are not appearing.
That I've already mentioned. I've already mentioned that they have not come.
And then there will be debate on this, whether that is a default. Maybe they are not interested like that, Lord. Some to pursue the matter or something like that, which will give up some handle.
If you hadn't brought this, I was planning to give them one more chance.
Then Lordship, let us deposit it there. And keep the Lordship, please keep the matter pending.
You brought it. No, you already brought it. You already brought it. What have I said? Just did the entire order. Long, okay. I will see. I'll try to, let me see how I can
Lordship.
modify. The contempt petition stands to. Of course, but for taking it out, they'll have to file an application.
Lordship. That is always open for them.
I can give back the thing, the check.
We'll deposit it in the. Lordship, is that observation that it will be deposited in a registry that,
Yes.
yes. Highly open. The other is the other side will come and take the checks now. Before 4 o'clock. Highly open.
May I please, your lordship?
Item,
Lordship,
44 to 46, madam. Admitted amount, madam, and
Lordship,
small amount that was not.
yes, madam.
I'm appearing I'm appearing on behalf of Mr. Dina for the respondents. Lordship, can we give, for the time, 10 days?
For what?
We're waiting for the instructions.
Last application, madam, given some more time, madam, the other side. Time, madam, the numbers of this they have taken for taking instruction. Small amount that can be, madam, released. Petitioner is, madam, bedridden, my lord, to even the medical treatment. Madam, the small amount, they can release that any moment, madam. Why they are
Madam,
getting
this case has been filed in 2022.
Lordship, 10 days.
Where is he? Where is Mr. Nath?
He's in Mason.
Huh?
He's in Mason, another court.
Supposing we wait for him,
Lordship, we're waiting for the instructions. Can we give them 10 days?
okay, we'll give 10 days then.
let fiction witness the next.
Mr. D. Nath Leonard, no, adjournment has been made on behalf of Mr. D. Nath Leonard, counsel for the respondents. On the ground that he has not received, he has not obtained instructions till date with regard to the payment of unpaid bills.
Right.
List the matter on, give a date. 15.
Hello,
All right.
Lordship.
Item 40 for hearing.
What is understood? Yes,
My lord,
item 40.
my lord, item 40. My lord, in this case, my lord, my lord, my senior advocate, Mr. Tisabante is on legs and another.
Who?
Let my senior continue, and then he will join me during this way.
My lord, this is the case for, my lord, award of tender in respect of a mining lease, my lord. There, my lord, the petitioner participated.
NIT dated
NIT, my lord, that is dated. 2023, my lord.
date.
Date is, my lord, 5/12/2022,
5/12/22, mining lease
my lord,
for 7 years,
for 1 year.
for 1 year,
For 5 years, for 5 years, my lord.
5 years. Let
5
us see, let us see, where is the lease page?
My lord, annexure 6 at page 20 is that, my lord, but then it is not very legible.
Page 20.
Yes, my lord. But then if your lordship takes up, my lord, page number. If the lordship takes up, my lord, page number, that is a more legible, my lord, at page 137, my lord.
Yes,
Yes, ma'am. At page 137, this is in the affidavit in opposition of the, my lord, private
this is the
respondent.
declaration.
No, my lord. Annexure A is the tender notice. This is legible, more legible, my lord. The other one with my repetition is not so clear, my lord.
Page 137.
137, my lord. That is, my lord, the. running page.
137 is this.
So they have the pagination is correct wrong, sir. If the lordship kindly takes up the.
If the court
affidavit-
pagination is wrong,
My
Mr.
lord,
Counsel,
my lord,
I'll
that
have
is
to
the-
keep running after you.
I understand, my lord.
So we'll have
Not-
to do it
that's not
either.
my document, my lord. It has been given by them, my lord.
But this is
Is
the
the
running page.
affidavit in opposition filed by the private respondent, my lord? Respondent number 7. The affidavit in opposition of the respondent number 7, my lord.
Mr. Counsel, I'm not on that.
My lord.
You see, the problem is if we are not on the same page, it's
My-
going to be a problem.
I understand, my
Now
I understand.
your 137 and my 137 is not. But anyway, what is the case? Tell me. in short.
Case is that, my lord, I was the highest bidder. my lord. When I was the highest bidder, my bid was rejected.
Okay.
And it was
They have
given,
two-bid system.
no, it was a single bid system. And it was given to the lowest bidder, my lord. Now the causes, my lord, for rejection of my bid was that in the court fee stamp which I had given, I had put my signature across the court fee stamp. That is why, my lord, it was found to be non-responsive. And my lord, the declaration which I had given along with my bid, my lord, that did not contain a date. But it is
Contain a date.
date. And that is no case that, my lord, that declaration was submitted later on after filing of the bid. So these are the two grounds, basically, my lord, as given in the affidavit by the state government, for which my lord, bid was rejected, my lord. Now, now, my lord, section 13 of the Stamp Act, my lord, it categorically states, my lord,
Signature was across
across the stamp,
stamp
my lord.
and no date
No date, my lord, in the declaration,
in the declaration.
my lord. But then, my lord, the committee, my lord, who assessed the tender, my lord, they find everything to be in order. That all documents properly submitted, everything is in order. They say that. But then in the affidavit, they come up saying that, my lord, my lord, signature was put across the stamp and there was no date in the declaration. That is why it was
Where is your disqualification, the impugned order?
that, my lord, there is no impugned order as such, but my lord, that it was rejected, my lord, and it was given to the private. respondent
Rejected
number
by
7.
whom?
My lord, by the authorities in the DTC, my lord.
But the district scrutiny committee had approved it.
Yes, my lord.
Is it?
Approved it that the comparative statement which was there, my lord. In the comparative statement, my lord, it was stated that everything is in order. And they have stated that in their affidavit, they have stated there, my lord.
Scrutiny committee have stated
At page number, my lord, 74 of the writ petition,
page 74.
74 of the writ petition, my lord. That is a part of annexure 9.
Yes, where are you?
Yes, my lord. I am, my lord, the first one, my lord, Surendra Boro.
All documents furnished and regular.
All documents furnished and regular. So for everybody, all documents were furnished and found to be regular.
Then
Then, my lord, just because, my lord, in the affidavit in opposition of the government, they say, my lord, just because, my lord, I had put my signatures across the court fee stamp. And my lord, my date was not given in the declaration. That is the reason why.
who has been selected?
My lord, the private respondent number 7, my lord, who was the last one, the lowest bidder, he was selected, my lord.
Vishnu Brahma.
Vishnu Brahma.
His respondent number.
Respondent number 7, my lord.
So he has offered lower than you.
Lower than me. In fact, among the 4 tenderers, my lord, he was the lowest. And he was considered, my lord, to be responsive.
He's mining this
My lord.
for sand and.
Sand.
So where is the affidavit?
The affidavit of the respondent number 2, my lord, that your lordship is on record. In my page, my lord, it starts from page 127.
Yes, sir, your juniors have to do, they have got to do it with the court record.
My lord.
Madam,
They have given it to us in this manner, my lord.
huh?
When we were served, my lord, with a copy, then the pagination was in this manner, my lord.
Anyway, but then you have got to, you have got to compare with the.
I have not done it, madam, I'm sorry.
You see, because one thing is that sometimes, you see, what happens is sometimes when the citations are given also, that is also put inside by the court, which is not a document given by either side. So that's why you have to have your own people go and check.
I'm sorry, my lord. I didn't do that, my lord. I have to have done it, my lord. From next time, I'll be cautious, my lord, for that.
Yes, para?
Paragraph, my lord, 5. 5 of the affidavit in opposition of the government, my lord.
Yes.
It says that, my lord, that with regard to the statement made in paragraph number 5 of the writ petition, the deponent begs to state that during scrutiny of the tender document, all the bidders of Rangapani SS Mahal were found to have submitted all requisite documents as asked for in a NIT. Further, all the bidders have obliged to the instruction given in the NIT while acknowledging serial number 12 of the tender paper by bidding value of up to 25% of the government fixed tender value. Then thereafter, my lord, in paragraph 8, it says, my lord,
Yes.
that everything was, my lord, complied. In paragraph 11, they say, my lord, that with regard to the statement made in paragraph number 12 of the writ petition, the deponent begs to state that on scrutiny of the tender from the petitioner, Mr. Surendra Boro, it is found to be incompletely filled up with respect to tender from point number 4, wherein the name and year and description like sand, gravel, boulder, stone, for which tender was floated was not mentioned clearly. Further, it was also observed that the petitioner, Mr. Surendra Boro, have not filled up the date on the declaration part on the tender form. And it was also observed that the code fee affixed on the tender paper was found tempered by signing on it by the tenderer. So basically, my lord, while they were considering the bid, my lord, of the SS Rangapani Mahal, which is the, my lord, bid in question. So, my lord, that perhaps non-mentioning because it was not considered for any other bid.
No, but
only
then
for
it
that,
says,
my lord.
it says it was found to be incompletely filled up.
Filled up.
With respect to the
Yes.
point, form number,
Yes,
form
my
point number 4.
My lord. And that is what that I have not quoted, my lord. I have not written the name of the bid. But when the consideration was for that tender, my lord.
Let
then
us
it
see
was
what it
taken-
is. For form number 4, what does it say?
My lord, it says
Let us see the bid.
tenderer, that is that annexure A of the affidavit in opposition filed by the respondent number 7, my lord.
Page.
That is the wrong page, my lord. In my records, it is 137 in the court's records. I don't know, my lord.
Government is.
Idea and application in opposition of the respondent number 7. 7. Rectification.
Seven.
147.
Your lordship got it, my lord.
Yes, where? Which?
Paragraph 4, my lord, lordship was referring to
Paragraph 4.
Paragraph 4, my tender should be addressed to the undersigned by designation and subscribed as tender for grant of mining contract for collection of so and so in the area shown in schedule of Dhonseri division, and the name must be put tender box kept ready for purpose in the office of the undersigned. So the scrutinizing committee does not find any fault because they say the documents are in order, as I have just pointed out to your lordship, my lord.
No, it just seems well. I don't know. Maybe they have got different role to play. Maybe they are just looking at whether the documents are complete or not.
My lord.
I don't know.
But then, my lord, because, my lord, ultimately the comparative statement was prepared, my lord, where, my lord, the bid of this petitioner was also considered, my lord. So it shows that, my lord, the bid was for that particular sand mahal only, my lord. Not without, my lord, countering to whatever has been stated, I say that we take it for, my lord, assumption that yes, I have not mentioned it. But when you have considered the bid for that non-mentioning is not so, my lord, great that, my lord, for that my tender ought to have been rejected because ultimately, my lord, I was the higher bidder.
That was to be seen, my lord. And the law is that the revenue, my lord, which is to be given to the government is the prime consideration, my lord. And my lord, that fact of my lord signing across the, my lord, port fee stamp, that is actually provided by the statute that it must, the counter, that port fee stamp must be, my lord, cancelled in that manner by signing, my lord. It is provided, statutorily provided by the Stamp Act, my lord.
Where is it?
The Stamp Act, my lord,
Yes, section.
paragraph, my, the section, my lord. Section 12, my lord, cancellation of adhesive stamps.
So far as the second check is concerned, that previous tax deduction and source will have to be deposited by the department to the income tax office.
Okay, so they have not
That
deposited.
may be, yeah, that will, my lord, on our own, we will deposit it. The main principal amount will
Okay,
be
so
deposited.
the interest portion is there, but the TDS on the interest has been, that will be deposited separately.
No, out of the total interest amount, whatever is the amount is to be paid, 10% will have to be deducted and it will have to be paid to the income tax office. So that we'll have to do, not before the registry. Only that part may be corrected. And we'll make, we'll deposit only one check before the registry. The main rate of principal amount.
You can come later and just remind me, but I might forget. Around 4 to 5.
Now, section 12 of the Stamp Act, my lord, it provides, my lord, subclause 3,
Subclause
3, my lord.
not the stamp act in Assam.
Stamp Act in Assam, my lord.
In Assam,
Assam,
you've got a separate stamp act.
yes.
Section 12.
12, my lord.
Yes.
Cancellation of adhesive stamps.
Hmm.
Whoever affixes any adhesive stamp onto any instrument chargeable with duty which has been executed by any person shall, when affixing such stamp, cancel the same so that it cannot be used again, and whoever executes any instrument on any paper bearing an adhesive stamp shall at the time of execution, unless such stamp has been already cancelled in manner aforesaid, cancel the same so that it cannot be used again. In clause 3, it says, my lord, the person required by subsection 1 to cancel an adhesive stamp may cancel it by writing on or across the stamp his name or initials or the name or initials of his firm with the true date of his store writing or in any other effectual manner. So, my lord, that cancellation of the stamp, my lord, by way of writing across is allowed by the.
Are you sure? Are you sure it wasn't the cancelled stamp?
No, my lord.
Cancelled earlier.
That they do not say. They say that because, my lord, I have put my signature across the stamp, that is why it is found to be unresponsive.
Okay, so that part, okay.
And then
Only
thereafter,
the
they,
first part is slightly problematic.
my lord. Then they say, my lord, that, my lord, the date of the declaration was not there, my lord. But then, my lord, it is also not the case that the declaration has been submitted after the deeds were submitted or whatever, my lord. So, my lord, non-mentioning of the date and, my lord, writing across, my lord, that stamp.
Okay, okay, those parts supposing we allow, okay, your submission.
My lord.
What about that first part?
First part of non-mentioning the name of the mahal, my lord. My lord, even we assume that it is, my lord, I say that I had mentioned it, my lord, but then if they say, my lord, that I have not mentioned it and assuming that I have not mentioned it, my lord. My lord, when they have.
No, no, where does it say again? Let us see.
In paragraph, my lord. 11.
Of affidavit of.
Affidavit of the government, my lord.
AC has to be put on, I think, very hot. AC. I'm starting to feel sleepy, I think. It's too hot.
My lord. Recently, my lord, temperatures are rising, my lord.
Huh?
Recently, my lord, temperatures are rising, my lord. Just now it is hot and then again it is cold, my lord. Very difficult, my lord. People are suffering, my lord, for that. All, my lord.
You are at least moving around, standing.
My lord.
We are sitting the whole day.
Yes, my lord. That
That's
is
the
also
problem.
difficult, my lord. My lord, in Delhi, I have seen, my lord. My lord, judges, my lord, get up.
Not the fan to off, AC.
In Delhi, my lord, I have seen, my lord, judges, my lord, getting up after, my lord, sometime for a 10 or 15-minute recess, where, my lord, they have installed, my lord, treadmills.
And they work in the treadmills for around 5, 10 or 20 minutes, my lord, or 15 minutes. And thereafter, after the circulation is there, my lord, they again come down, my lord. Because sitting, my lord, like this
Yes,
the whole
yes.
day, my lord, it affects, my lord.
Like that, because of this only, I was having treatment in Delhi for 3 weeks last year.
My lord,
Couldn't move. I had to go in a wheelchair from there.
my lord.
Very embarrassing.
My lord, nowadays there are some cushions, my lord, medicated cushions, my lord, for the back as well as the, my lord, glutes, my lord. Lordships can, my lord, have.
I've got.
My lord, so that at least gives some relief, my lord. So basically, my lord, this is the case, my lord, and I say, my lord, that these are not conditions for which, my lord, the tender could have been, my lord, dismissed, my lord, rejected. And my lord, because I was the highest bidder, my lord, I ought to have been, my lord, considered, my lord. And because there is a judgment of the Supreme Court also which differentiates, my lord, that there are two types of consideration. One type of consideration is which goes to the, my lord, very root of the matter, my lord, and others which are, my lord, for the states, my lord, lordship is aware of that, my lord. So on that ground also, my lord, my tender ought to have been allowed, my lord, being the highest bidder. And that is, my lord, there is no, my lord, ambiguity on that, my lord, they will also admit that I am the highest bidder. And I ought to have been allowed, my lord.
Now, what is the stage now?
Stage is that, my lord, I am told, my lord, that they are running it, but my lord, my learned friend says that the, my lord, EC clearance has not yet been received, and that is why, my lord, they are not, my lord, in a position to run it. They are running it, they are awaiting the EC clearance, but the law says that initially, my lord, the EC clearance and all those things, my lord, has to be taken beforehand, my lord, by the employer, and then the, my lord, bid should be offered.
Yes.
So, my lord, is not the law, my lord. Actually, after getting the settlement.
Have you started the work?
I have not yet. Preliminary groundwork we have done.
They
But,
have started, my
but
lord.
regarding my lord, EC clearance, I cannot start because the detection, we cannot start because we have to wait for the clearance of the environment. That is most important, my lord. And that we can apply, my lord, after getting the settlement order and signing of agreement. Along with those documents, my lord, we have to file the before the environment clearance. Now environment clearance, that board was not constituted, but now it is constituted. So,
it's the right time to hear this case.
Yes,
my lord,
yes, my lord.
the mining plan is approved, but EC clearance is yet to get.
The issue is basically this. Whether.
No, my lord, may I
uh,
submit, my lord? My learned friend, my lord, saying that he is the highest bidder. That is statement is not correct, my. Your lordship kindly sit down.
Correct, there is another one.
Same price, the same price, another one.
Same rate.
Same rate, my lord. And my lord, what my statement in the affidavit, my lord, they have done, my lord. Your lordship kindly go to the record, my lord. What, my lord, he has missed out, my lord. Your lordship kindly see page 157, my lord. Probably it is a correct page, my lord, with the NIT. Page 157.
Yes,
At 157, that is the NIT, my lord. Has your lordship got it?
yes,
And that is clause 13, my lord.
yes.
The tender paper must be accompanied with the following document. Very first line, my lord.
Yes.
The passport size photograph, tender attested. That is also missing, my lord. Your lordship kindly see the affidavit filed by the government, my lord.
No, but then the government does not say this.
But that is from the record I am submitting.
No, how does it
No,
matter?
and no declaration form.
No, you see, Mr. Counsel, when the government,
My lord.
they have not taken these grounds. Who are you to take these grounds?
No, my lord, another ground, my lord, he has not, they have not signed the declaration form, my lord.
I have signed it, I have not given the credit.
Your lordship kindly see 13E, my lord. Other information required to be submitted as stated in the tender form as per rule. Your lordship kindly see the page 137, my lord. 137, my lord. 137, Surendra Boru, my lord. Surendra Boru is the petitioner here.
I think I need to take a walk. I'm yawning like anything.
My lord, sorry, my lord. Sorry to you.
No, I'll just take a walk. I think I might.
Yes, my lord. Please resume after 10 minutes. My lord.
Huh?
No, I am asking that.
Huh? How long will you take?
No, my lord, I will not take much time, but main important fact is that.
No, no, you see, I will not take much time, will not do.
My
Come
lord,
on.
sorry, sorry. At least within minute.
My lord, let us come back after 10 minutes, my lord, if your lordship permits.
No, 9:04.
Time.
What? One motion is there.
Then can it be on some other day?
And Tuesday. Yes.
Yes, my lord.
This
Suffocating
is-
suffocating.
It's not Tuesday, my lord.
Today she's got all the records.
But very important record is not been there. She told me. Important the document is there, but minutes of the meeting. What is the consideration? Because definitely tender evaluation committee take a decision why it is given to me. That is very
Okay,
important, my lord.
okay, right. Heard Mr. G. Chowdhury. Learned counsel for the petitioner who submits that the petitioner participated in a NIT dated 5/12/22 for settlement of a mining lease for sand for 5 years. So, the petitioner's bid was, however, disqualified on the ground that the petitioner's tender had not been filled up in respect of point number 4, whereas the name, slash year slash description like sand slash gravel slash boulder slash stone had not been mentioned clearly. Further, the petitioner had been tampered. No, the petitioner had signed on the court fee stamp. Besides, the declaration form did not contain the date.
My lord. But if your lordship kindly turns to
Stop.
page number 100.
Just a minute,
Yes, my lord. The name is also there. I had given the name.
Yes, sir. The petitioner's counsel submits that in terms of section 12 of the Indian Stamp Act 1899,
My lord. Assam stamp.
the Assam Stamp Act, what is the year? This
My lord, this is the Assam amendment to that Indian Stamp Act, my lord. 1899.
the Assam Stamp Act 18, no,
Indian Stamp Act 1899, my lord, the Assam amendment. My lord.
as per section 12 of the Indian Stamp Act, 1899, which was amended for the state of Assam,
My lord.
comma. Section 12, you said, no?
Yes, my lord. Section 12, subsection 3, my lord.
Like section 12, bracket 3, huh?
Yes, my lord.
A person is required to cancel an adhesive stamp by writing on it or across the stamp his name or initials. In respect of the in respect of the petitioner not putting a date on the undertaking submitted by him, he submits that no prejudice is caused to the respondent, as it is not the case of the respondents that the petitioner did not submit his undertaking in time, or that it in the undertaking in time. What about the first part?
First part I have mentioned, my lord, if your lordship kindly takes, my lord, that page number 135, my lord, of the affidavit of the private respondent, my lord. Of the government, my lord, page number, that is the annexure A to the government affidavit, lordship will find in clause 4, the name of the mahal has been given, my lord.
Yeah. Yes.
Which one?
Yeah, yeah.
My lord, it is annexure A to the affidavit in opposition filed by the government, my lord, at page 135.
Yes.
There your lordship finds at clause 4, I have given the name, my lord. Rangapani SS Mahal.
So,
So I have given the name. It's not that I have not given the name, I have given the name.
in respect of the third allegation, he submits that the name of the mahal has been given by the petition. Comma, though year was not mentioned. Next. Due to paucity of time, list the matter again. And
Yes.
Thursday. Thursday.
My lord. Keep that. My lord, this Thursday, my lord, coming Thursday.
Not tomorrow.
Next.
Next. Not tomorrow.
My lord.
Okay. Because there's no time.
My lord. Let it be on 14. Can it be on 19 then? 19.
19, we've got some full bench matter. So,
Let it be on 14, my lord, because it is on record, my lord. Everything is on record.
he's got some difficulty.
On 12, my lord.
18,
On 12, my
21st.
lord.
21st. 21st.
21st. I'm with you, my lord.
What is your case?
If I may, as I had mentioned in the morning as well, but this is a straightforward case wherein the name of the petitioner has been omitted or removed from the final electoral roll. Now, there have been many violations in this case. I will first lay down the rights that is.
I don't have time. I don't have time. to hear. Now, you see, can we decide this issue first of all?
Manoj, there is a
Yes, sir.
procedure. There is a procedure laid down in the Representation of People Act,
Then?
read with the Registration of Electoral Rules 1960. There has been violation of both. The violation, Manoj, the petitioner, his name was recorded in the draft electoral roll, and a certified copy is
Have
also.
you
given.
made any?
Yes, Your
representation?
Lordship.
Lordship, the final, he's saying that from the final voter list to 2024, that has not been annexed to the writ petition. We cannot ascertain.
Manoj, that is the whole issue, that the name is not there. How can I show something which is not present? But I've annexed the draft electoral roll wherein my name is present. Your Lordship may kindly come to the annexures, my Lord.
If it is in the draft, then automatically it will become in the final.
Show me the draft.
Yes, Lord. Your Lordship may kindly come to annexure A2. A1 is the certified copy, page number 15. Page number 15 of the writ petition. Annexure 1. This is the
Yes.
Your Lordship has it. This is a copy of the certified copy of the electoral roll issued
Yes.
by the election office.
Yes.
Here, Your Lordship will see on the next page, the
Yes.
serial number, the name, the father's name, and everything is present. Now, the next page is the typed copy at page number 19. Your Lordship will see an extract of the draft electoral roll from 2023. At the bottom, Your Lordship will find at serial number 179, this is the petitioner. This is an extract. Then, at page number 20, Your Lordship will notice, Your Lordship will find the EPIC electoral photo identity card issued to the petitioner. And what has happened is that his name was not found. Then we approached the Election Commission in person, wherein we were told.
Name is not found?
Yes, my lord. It's nowhere in the electoral roll, and then we punched the EPIC number on the website as well, and no detail came out of that. Now, the mood problem is that they've bypassed the procedure that has been laid down in the Representation of People Act. Now, if I may quickly, and also their own executive instructions of the ECI, my lords. Now, in a very similar case, my lord, I'll just take your lordship to this judgment. This contains the recourse that was taken by the Honorable Court, my lord. Here also, your lordship, the same thing happened. The person's name was removed. Now I'll take your lordship to page number 7 of this judgment that I'm relying upon. Page number 7.
Yes, yes.
Paragraph number 9. I'll straight away take your lordship to the italized part, the extracted portion of section 22 of the Act of 1950, which is the Representation of People Act, correction of entries in electoral rolls. If so-and-so, next page, the proviso, straight away the proviso. Provided that before taking any action on any ground under clause A or clause B or any action under so-and-so on the ground that a person concerned has ceased to be ordinarily resident in the so-and-so, the electoral registration officer shall give the person concerned a reasonable opportunity of being heard in respect of the action proposed to be taken in relation to him after proper verification of facts in such manner as may be prescribed. On an evaluation of the said provisions, it is explicit that they are peremptory in nature and can never be brushed aside or overlooked. Proviso thereto makes it clear that before removing a person from the voters list, the electoral registration officer is duty bound to give the person concerned a reasonable opportunity of being heard in respect of the action proposed to be taken, which thus also means the action or inquiry contemplated under so-and-so is not an empty formality, but on the other hand, founded on principles of natural justice, which if violated, action becomes so-and-so. Now, in this case, in the operative portion, the Honorable Court directed the concerned election office to at the name of the petitioner. Here also, we have already preferred representations to both the Chief Electoral Officer as well as the District Electoral Registration Officer.
We cannot say that add him. They'll have to see.
My contention is that till the disposal of this case, they can take an action on the representation, and if it is in the affirmative, then my relief will already be granted to me. And there would be no need to proceed further, and it can be closed accordingly.
Because paragraph 6 of the judgment lordship, it says that the electoral roll was some specific date was there. On that day, the final electoral roll was published on such a date. But in this case, we cannot say it is published or not. From where he has come to know that his name is not there.
Is the final electoral roll published?
But on the website, they have a 2024 list. There's no mention. And then just to verify, we punched our name onto the portal. Onto the portal, we punched our EPIC number and no detail was provided to us. The EPIC which have annexed.
You see, out here in SAM is a slightly different kettle of fish out here. You've got a lot of these foreigners tried with a lot of issues.
That's true. But if I may,
so we cannot decide. We cannot say that he should be put in now. We don't know. Something might have happened.
Yeah, just 1 second, Balaj. If I may take your lordship to the executive instruction, the last annexure, if that will clarify the entire situation, my lord, at page number 38. Page number 38 of the writ petition. Page number 38. Your lordship has it.
Yes.
This is under the heading of prevention of wrong deletions. B and D are of pertinence here. B reads, no deletion should be done without following due process of law as contained in the RPI. So that is what has happened. So in all cases, a notice must be issued to the elector and must be duly served on him, which has not happened here. In cases where the elector is not found living at the address, so and so. D, special care must be taken for deletion of names of persons who have already been issued EPIC. EPIC is annexure A3 in this writ petition, that has been issued. And the next page, page number 39, the Roman number 3. Whenever any entry is deleted from the electoral roll, an SMS and email should be sent to the concerned elector if his mobile phone or email is available in the electoral database. Nothing of that sort has happened. And in fact, when we
We
approached
don't
them,
know, that is your submission.
but why I'm saying
Your
this is
lordship
because when
also
we
correct.
approached them, they made us fill Form 6. That also have annexed, which I've submitted. Now, Form 6 is misleading because Form 6 is submitted when a person is willing to desirous to become a first-time voter. They made me fill that Form 6, and since I was ignorant, I know I cannot take that plea here, Milord, but they made me fill up Form 6. I've annexed that also, Milord. Even then, no action has been taken. If they are not going to restore my name, at least add my name as a first-time voter. And in these instructions also, the last annexure, your lordship, on perusal, your lordship will find that an express bar has been given that after announcement of elections, modification becomes an almost logistical impossibility with us. That is why we have approached with such urgency in this matter, and we've also preferred a representation with us. Therefore,
You should go to the election commission.
I've gone, my lord. The representation is also next. The representation is also
Yes.
next.
I am not for the election commission of standing because here in the court is ECI, Election Commission of India, it is named so. Perhaps it should be the R2B, the State Election Commission. R2B State Election.
Have you not served the copy on?
Well, we have duly served it.
No,
There is no chief election officer India, my lords. The respondent number 1 is the chief electoral officer Assam, and second is the election officer Karimganj. There's no election commission of India. Both Assam.
Election Commission, respond number 2, I am
Karimganj
appearing.
is a dangerous area.
So Karimganj is the
Respond number
representative.
2, I am appearing because representation is not before the respond number 2. It is-
No, representation has been referred to them also. I have annexed it. The receiving-
Anyway, but this issue cannot be decided by us straight away.
My lord, in the
Not without some instructions from the.
that is my prayer, my lord. Instructions may be called, and in the meantime, they may take a decision on the representation. And if it is in the negative, then of course the writ petition will continue. But if it is in the positive, then this case can become.
Where is the representation?
Let's the representation is annexed at as A5, or as annexure 5 collectively at page number well,
Is
23. 23 is the receivings are available at page number 26 to the respondent number 2 and 27 to the respondent number 1. 23 to 26, the text of the representation. We have canvassed the entire facts of the case there. And this is, so they can dispose of this, they can take action on this representation, my lord. In the meantime, while seeking instructions.
So let them take a decision on this. That's all.
Yes.
Why should we keep this pending?
My lord, if
If
at all,
it doesn't go, then there's the appellate authority. You cannot come here all the time.
but my lords, in the judgment that I have furnished right now, my lords, there an action was taken by the court, my lords.
Maybe, but out there, you see, the court had the opportunity of listening to the other side.
That's why it may be kept pending, my lord, instead of being disposed of.
Let it
While
be
they call
passed in
instructions.
Presence of the Standing Council of Election.
It can be disposed of on the next day,
In
my
the,
lord.
presence.
Because it is a straightforward matter, can be disposed of on the next day.
Where?
R2B.
How to be not here?
State. State. No.
It can be disposed of on the next day, my lord, while they seek instruction. And representation, if at all the representation is disposed of by them in my favor, then there will be no need to proceed.
Respondent number 2 is the election officer Karimganj, but they have filed the representation before the electoral registration officer Karimganj.
My lord, that
I
is,
don't know what is.
but the receiving is of the election officer, your lordship McAllister, page number 26, election officer.
What is the address?
How can that stand be taken? My lord?
It is address
No,
to
no,
the.
no. You see, many things happen here in Assam.
Yes.
It has been duly received by the election officer.
From where they have come to know that their name is not there, no such ever, my lord. Fine.
They may come with the instruction. If they come with the instruction that my name is there in
First,
the
they have
voter's
to
list,
establish their
then there will
case.
be no need to proceed.
They have to establish their case.
This representation was page 20.
23.
23.
Chief Electoral Officer, Chief Electoral Officer. District. Commissioner. This was issued, what is the date? No date.
My lord, the letter, my lord.
Yes, your letter has no date.
It has, my lord, right below the respondent number 2's address, date 1st of March 2024, page number 23.
If that is 1st of March, 2020, come to page 26.
Yes, my lord.
What is this date? Four
Received
two.
by them.
How can it be received prior to the letter being issued?
2000.
It must,
can it be?
it must be my lord, a typographical error
No,
because
no.
my lord, because it was received by them, then they should be the ones answering that.
I don't know. Mr.
Please, the
Counsel.
next page, may kindly see, your lordship may kindly see, the next page. The one received by the respondent number 1.
This is a different document. Isn't
The
it?
same representation was served to both the officers, my lord. It was served, I fairly submit that it was served on the same. Well, in either case, this has been received by them. The letter is dated 1st of March 24.
Or maybe it's made by your as if to show that they had received it. How can it be received by them prior to the issuance of the letter? 1st March is your letter. They've received it in February, when it's not even in existence. Supposedly not in existence. And this also doesn't show as 24.
Well, that is an action done by them. Well, how can I be penalized for a wrongful entry of date by the respondent?
I don't know. Maybe you have fabricated this
But
document.
well, then let them see that. Let them see that, Mullahs. Why would I fabricate a representation, your lordship?
I
before
don't
coming
know.
to this
I don't know.
This is a genuine case where I have
Is
annexed.
there an alternative remedy available? Supposing if the CEO does not do it, then who do you go
The
to?
courts, my lord, in all, the Honorable Supreme Court has also directed election commissions to include names.
As per the Representation of People's Act, is there any other alternative remedy? Is there an appellate authority?
Well, I've come before this court, my lord.
No, I'm asking you. I know you have come before this court.
Yes.
I'm asking you a legal question, a legal point of law, whether there is an appellate authority or not.
Well, as per my knowledge, my lord, and upon perusal of the judgments, my lord, since the Honorable High Courts have always intervened, my lord.
No, that I'm not. I see. I'm not talking about
Yes.
whether we can intervene or not intervene. I'm asking a very simple question: whether there is an appellate authority or not. You mean the representation of people that. Appeals. So it will be under the registration of electors rules.
That is, those are rules formulated under the RP Act.
And this 23 of the registration of electors rules will it come into play?
But this is when there are claims and objections. And if there are claims and objections, then a reasonable opportunity of being heard is to be given to the aggrieved or purported to be aggrieved person. Then that will come into play. But there is no claims, no objections, because no notice was served to us, no hearing was granted to us. No opportunity was afforded to us to controvert any allegation. Therefore, all these factors were taken into play in the judgment that I have just
Appeal
quoted.
from order deciding claim and appeal shall lie from any decision of the registration officer. Any decision of the registration officer under
Under
Rule
Rule
20, 21 or Rule 21A.
Yes, my lords. And all these,
Deletion 21A speaks of deletion of names.
yes, my lord.
To such officer of the government as the election commission may designate in that behalf.
Yes.
Hereinafter referred to as the appellate officer.
And this was taken into consideration because the proviso of
So who
21
is the appellate officer here?
that is to be, my lord, elucidated by the respondents.
So it seems there is a provision.
Well, that has been discussed in the judgment, that provision will only come into play when the proviso has been honored. The proviso states that notice has to be given, an opportunity of being
That
heard
is
has
a
to be given.
question of fact, which will have to be decided first.
That is why, my lords, my humble prayer is that instructions may be called. And in the meantime, my lord,
Lordship, perhaps Topi has been served on the wrong council because in the cause list, Standing Council Election Commission of India is shown, but they have made the party. So we have the state election, Assam State Commission of
I don't know.
Election Commission of Assam. There's council are to pay.
Because instructions is to be called, then it has to be from the state,
Yes, yes. So
from Karimganj, from Karim,
from the state. So
whatever
he's saying probably you have given your writ petition copy to the Election Commission of India Council.
because
I have been informed that we have right.
Well, I don't,
I have not
because
checked
now
it out, but
we cannot ask him to who do it, I direct to take
yes,
instructions.
yes.
My lord, the electoral registration officer of
He's
Karimganj,
not here.
but Karimganj is here, my lords.
But the Karimganj is there. What
Who is, he's not the person.
But there are only two respondents. If one is absent, then the learned counsel must be from the second one.
Your appeal for whom?
for the election officer?
Yes, Karimganj.
No.
Respondent number 2, Karimganj.
But he has filed representation, whatever he has submitted before the electoral officer.
You find out.
Yes,
You can take it up. You take it up. Right.
and in the meantime, my lord, the representation.
How
may be
does
got
it
to be-
matter? It's at the same office.
Yes, yes, absolutely.
Yeah. Just find out how is it. Since you have taken it up. Heard, Mr. Yes, what is your name?
Anjan Sahu. my lord.
Anjan Sahu.
Yes.
Your name is not here. Acha, okay. Learned counsel for the petitioner. Who submits that the petitioner's name has been deleted from the final electoral roll / voter list of 2024 pertaining to the Karimganj Lok Sabha constituency. So he submits that the petitioner had earlier been issued an elector photo identity card number HXH 1772581 in the name of Aminur, AMINUR, Rashid Chowdhury, SCHOUDHURY, Chowdhury. And in the, what is this page 19?
19 is the extract of the, from the draft electoral roll, whereby
And in
19 was
in
present.
the draft electoral roll for 4 South Karimganj, part number 71, segment number 1 Nilam Bazar and Nilam Bazar railway station, comma. The petitioner father's name was shown as Abdul Muqtadir, MUQTADIR,
Yes.
Chowdhury. House number 103, page 53, page 18, huh? Page 18. He submits that in terms of the proviso to Rule 21 of the Registration of Electors Rules 1960, comma, deletion of a voter / elector can be made only after reasonable opportunity has been given to the said person with regard to the action proposed to be taken against him. He submits that in the present case, no notice was issued to the petitioner prior to deleting his name from the final voters list. Made in the year 2024. He submits that he came to know of the same when
We punched the EPIC number on the web portal.
when he punched the EPIC number of the petitioner in the web portal.
But it is not stated in the petition.
That's not stated.
No, Lordship. Only paragraph 2 and 5 speaks about the omission.
Where is their earlier final voter list? There must be an earlier final voter list.
My lord, that has not been annexed here, but since his name was present in the draft voter
He has
list,
got an epic.
yes, we have epic, my lord.
Yes, let's find out the epic. Let's find out. How does it matter?
But from where he has got that knowledge that his name is not found, that should be.
No. Anyway, it's his submission.
Whatever.
It's a submission. That's right. Mr.
SR Borwa.
S.R. Barwa. No, before that, he also submits that though the petitioner has submitted a representation dated
1/3/24,
1/3/24 to,
both the respondents.
no, where is that page?
Page number 26 and
Not
27, the
that.
receiving.
Not before us, Lordship.
To the Chief Electoral Officer, Assam, and the
Officer.
Electoral Registration Officer.
But it has been received by the election officer, same office.
No, Lordship.
No decision has been taken by them till date. Mr.
SR Borwa.
S.R. Barwa appearing for the
Respond number 2.
point number 2. Will obtain instructions from the office of the election officer Karimganj as to why the petitioner's name is not found in the final electoral list of voters for the year 2024 for the Karimganj Lok Sabha constituency. He obtained instruction, Mr. He wants to, let him have a vote if he's, or let him at least challenge it. To stop. This is the matter. When can you have, let's this is the matter on 30th. In the meantime, the respondents may take a decision on the petitioner's representation.
Okay.
Dated
Lordship.
Say 1/3/24.
Lordship, one prayer. In the meantime, they will serve the copy to the correct council.
To stop. The petitioner shall also serve copies of the writ petition to Mr.
R. Dubey.
R. Dubey, learned counsel for the state election officer,
Yes.
state election officer,
Assam.
Assam.
Chief Electoral Officer.
Chief election officer, Assam.
State Election Commission Assam.
No, state election commission will not be involved in this. State election commission, they are involved in panchayat elections, all these other elections. They are, you see. So there's a difference. State election commission have got no role. Okay.
Direction for disposal of representation.
Huh?
Direction for disposal of
I've already said no.
Very well.
In the meantime, they may take. Since you have come here, I have no direction will be first.